9. Implications of the rights view. In this final chapter, some of the implications of the rights view, as these relate to our treatment of animals, are explained and defended. It will not be possible to examine the enormous variety of ways in which human acts and institutions affect animals. In particular, such activities as rodeos, bullfights, horse and dog racing, and other public sports involving animals will go unexamined, as will petting zoos, roadside zoos, and zoological parks, including aquaria, and the use of animals in circuses and in the film industry. These uses of animals are not examined, not because they are unimportant, but because others, which are either more common or more celebrated, require pride of place. By making it clear what the rights view's position is regarding those activities and institutions that are examined, it should be clear what its view would be regarding many of those that are not. The 4 areas that will concern us are raising and consuming farm animals, hunting and trapping wild animals, saving endangered species of animals, and using animals in science. The discussion of endangered species will provide the occasion for some further remarks on environmental ethics and concerns. 9.1. Why vegetarianism is obligatory. The right of animals not to be harmed is a prima facie, not an absolute right. In saying this, we concede that there are circumstances in which this right may justifiably be overridden. Because animals are not moral agents, their rights cannot be overridden on the grounds of punishment of or defense against the guilty. However, because they may pose innocent threats and may be used as innocent shields, and because the right of any innocent may sometimes be overridden in such cases, the rights of animals prove no exception. But the harm done to farm animals, for example the deprivations they are caused in intensive rearing systems, cannot be defended on the grounds that these animals pose innocent threats or occupy the unenviable position of innocent shields. In order to inquire into the moral acceptability of the harm done to farm animals, therefore, we must first ask how one could most plausibly attempt to defend this harm, given that these animals pose no threat and are not innocent shields. The liberty principle. The rights view recognizes the right of the individual, subject to certain qualifications, to do what is necessary to avoid being made worse off relative to other innocents, even if this involves harming innocents. The need for certain qualifications should be apparent. For example, just because I would be made worse off relative to my neighbor if I do not take possession of his Mercedes, it does not follow that I have a right to take possession of his car. Indeed, without appropriate qualifications, the proclamation of this right of the individual would be a license to moral anarchy. The following statement of this right, the liberty principle, adds the necessary qualifications. Provided that all those involved are treated with respect, and assuming that no special considerations obtain, any innocent individual has the right to act to avoid being made worse off, even if doing so harms other innocents. The special considerations proviso explains why I am not at liberty to take my neighbor's Mercedes, just because not having it would make me worse off relative to him. For since it is his car, he has a right, assuming the car was acquired justly, in addition to our mutual right not to be harmed, and the possession of this additional property right is a special consideration that limits my liberty. The second proviso, namely, provided that all those involved are treated with respect, rules out other cases. If, for example, I would be made worse off relative to my Uncle John if I were to forego the pleasure of torturing him of an evening, I may not do so in the name of exercising the right in question, since to harm him merely on the grounds of the pleasure I would derive would be to fail to treat him with the respect he is due. So the right in question is not a license to moral anarchy, but is instead one that has important qualifications that are recognized and justified by the rights view. To say that we have this right is to say that we are at liberty to act in the way the right authorizes, and to say that we are at liberty so to act is to say that it is morally permissible to do so. We may refuse to do so, But were we to refuse, we would be doing more than duty strictly requires. That is, we would be acting supererogatorily. Were I to refuse to do what is necessary to avoid being made worse off, subject to the provisos listed, I would be acting in a self-sacrificial manner, voluntarily arranging it so that I am the one who is made worse off relative to the others involved. This I may do, certainly, but I have no duty to do it, nor does anyone else have a right against me to do so. The liberty principle is derivable from the respect principle. As an individual with inherent value, I am always to be treated with respect, and thus am never to be viewed or treated as a mere receptacle, or as one who has value merely relative to the interests of others. Moreover, since, like other such individuals, I have a welfare, I may do whatever is necessary to advance it, subject to the same moral constraints that apply to all moral agents. To deny me the liberty to pursue my welfare simply because others will be less well off if I do is to fail to treat me with the respect I am due. It is to assume that the treatment I am due as a matter of justice is contingent upon how others will be affected as a result, either individually or collectively. But the treatment I am due is not contingent upon these considerations. It is not contingent upon collective or aggregative considerations, since such a view assumes that I have value merely as a receptacle, and it is not contingent upon the interests of any other particular individual, since as one who has inherent value, the respectful treatment I have a right to is not contingent upon anyone else's interests. To claim, then, that I may not do what is necessary to avoid being made worse off, assuming all involved are treated with respect and in the absence of special considerations, because of how another or others will fare as a result of my efforts, is to fail to treat me with that respect I am due. And the same is true of all those individuals who are intelligibly and non-arbitrarily viewed as being the subjects of a life. None may have his or her liberty limited on grounds that assume that the individual is a mere receptacle or has value merely relative to the interests of others. All who have inherent value, therefore, have the equal right to do what is necessary to avoid being made worse off, subject to the provisos of the liberty principle, even if this requires doing what will harm other innocents. It should be clear that an individual's liberty right is not restricted only to cases where individuals who exercise this right themselves directly harm others. If the A's harm the B's, and if I would be made worse off relative to the B's if the A's did not harm the B's, then I act within my rights when I support the A's, provided the other conditions of the liberty principle are met. I may choose not to act within my rights, with the result that I am made worse off, but I have no duty to do this, and those who are harmed, the B's, have no valid claim against me to allow myself to be made worse off by choosing not to exercise my right to support the A's. In addition to the respect, the harm, the minoride, and the worse-off principles, then, the rights view recognizes a fifth principle, the liberty principle. It is this principle, it seems, that is most likely to figure in attempts to defend raising farm animals for human consumption and consuming them. For since both farmers and meat-eaters are authorized to act as the liberty principle allows, they may claim that they are at liberty to raise and eat animals, respectively, even though this involves harming animals or supporting those who do, since not to do so would make them worse off relative to any of those individuals who are harmed in the process. That is, relative to any farm animal. Moreover, to attempt to deny farmers and meat-eaters their exercise of this right in the present case by aggregating the harms done to the many animals involved would be to treat the farmers and meat-eaters as if they were mere receptacles, something that on the rights view we must never do. So while both the farmers who raise animals for human consumption and those who consume them could concede that others may elect not to eat meat, they could argue that they are within their rights, that they do nothing wrong in producing meat or eating it. The rights view denies this conclusion while at the same time conceding the validity of the principle from which it is supposedly derived. The argument just given is sound only if the case can be made that raising animals to eat and eating them satisfies all the requirements of the liberty principle. Once we examine the matter more closely, we shall see that it fails to do so. What could be the grounds for claiming that the harm done to farm animals can be justified by appeal to the liberty principle? Some of the relevant considerations concern the putative harms that would be done to consumers if they did not eat meat. Among these, the following are the most frequently cited. 1. Animal flesh is tasty, and to abstain from eating it is to forego certain pleasures of the palate. 2. It is personally rewarding to prepare good-tasting dishes, a benefit we would have to deny ourselves if we chose not to eat meat. 3. It is our habit, both perhaps as individuals and as a culture, to eat meat, and eating it is convenient. To abstain would be to endure the pains of withdrawal and the loss of convenience. 4. Meat is nutritious, and to cease eating it is to ruin one's health, or at least to run the very serious risk of doing so. Among the considerations that relate to those associated with the meat industry, the following are the main ones. 5. Some people, for example farmers, meat packers, wholesalers, have a strong economic interest in continuing to raise farm animals, and the quality of their life, as well as that of their dependents, is materially tied to a continuation of the present market in food animals. 6. Not only those who are directly associated with the farm animal industry, but the nation generally has an economic interest in the maintenance and growth of this industry. 7. Farm animals are legal property, owned by farmers, and that gives farmers the right to treat their livestock as they wish, even if this is harmful to these animals. 8. Some farm animals, most notably chickens and turkeys, are not directly covered by the principles prescribed by the rights view, so farmers are at liberty to treat these animals without regard to these principles, and for similar reasons, consumers are at liberty to eat them. Let us consider each of these considerations with a view to determining how well or ill they can justify the harm done to farm animals. Taste and culinary challenge. Neither one nor two, nor both together, can justify overriding the right of animals not to be harmed. This is clear for several reasons. First, and most obviously, no one has a right to eat something just because they happen to find it tasty, or just because they happen to derive satisfaction from cooking it well. If Heather just loves the taste of children, it hardly follows that Heather has a right to cook them. Nor will it do for Heather to protest that we violate her rights when we put a stop to her culinary adventures. If Heather violates the rights of those she cooks and eats when she cooks and eats them, then she has no grounds to complain that we violate her rights by stopping her. To suppose, then, that the issue at hand concerns whether our right to eat animals outweighs their right not to be harmed is to beg the essential question. It assumes that we have this right in the first place. That we do, if we do, needs to be argued, not taken for granted. Second, there are many other tasty foods besides those that include meat, and the rewards we can achieve from our culinary accomplishments can be achieved just as well without using meat as by using it. So we are not being asked to choose between two mutually exclusive options. Either eat tasty food and take satisfaction in creating tasty dishes, or eat tasteless food and forego the satisfaction of cooking tasty dishes. Put another way, we are not being asked to choose between eating and cooking with meat or harming ourselves by depriving ourselves of opportunities for the pleasures of the palate and the pride of having prepared good food well. And if we are not being asked to harm ourselves by depriving ourselves in these ways, then we cannot justify supporting those who harm animals because of any harm we would have to endure as a result of loss of taste or culinary rewards if we stopped supporting them. Third, even supposing we were harmed by foregoing eating and preparing meat, the harms we would be called upon to endure could not reasonably be viewed as prima facie comparable to the harm visited upon farm animals. Those animals raised in modern factory farms, for example, are daily harmed, both because of the suffering they are caused and the deprivations imposed on them. In comparison to any harms we would be called upon to bear if we were to forego eating them, the harm routinely done to these animals is, prima facie, much greater. and thus makes these animals prima facie worse off. Appeal to the liberty principle, therefore, would not justify our continued support of those who harm farm animals on the grounds that foregoing our culinary interests in meat would make us worse off. 3 objections are worth considering at this point. First, it might be objected that the foregoing shows only that we cannot justify harming those animals who are raised in close confinement systems by appealing to the harms that would be done to us if we refuse to buy and cook meat that originates from these animals. The situation of animals who are raised humanely, it might be claimed, is quite another matter. If we would take the pains to ensure that we eat and cook only these animals, this objection holds, then our gustatory and culinary pleasures rightfully prevail. This objection conveniently overlooks the prima facie harm that death is, not only for us but for the animals in question. An animal whose life is brought to an untimely end, before killing can be viewed as a merciful act, defensible on paternalistic or preference-respecting grounds, is prima facie harmed, even if raised and slaughtered humanely. All that animal's future prospects for satisfaction are denied. We, on the other hand, were we to forego eating their flesh, would be called upon to give up a pittance of satisfaction in comparison. It is these animals, then, not us, who are prima facie made worse off, when the harm done to them is compared with the harm we would be called upon to endure if we were to forego the pleasant taste of meat and the challenge to cook it well. Second, it might be objected that the foregoing shows only that, stationed in the world as we are, we should eat less meat, not that we should eat none at all. We should, that is, reach a grudging compromise between our culinary preferences and respect for the rights of animals. We'll eat less of them, thereby foregoing some of our pleasures, and they ought to be willing to meet us halfway, so to speak, by acknowledging that the harm done to them isn't everything. Isn't that an equitable middle ground? The answer, according to the rights view, is negative. Fundamentally, it is not the number of animals that matters, though the numbers involved compound the wrong. Fundamentally, what matters is that animals, whether raised in close confinement or humanely, have their life brought to an untimely end for purposes of human consumption and, as a result, are caused prima facie greater harm than any of us would be if we gave up the pleasant taste of meat or the joys of cooking it well. If a single animal was slaughtered merely on the grounds of human gustatory preferences and culinary challenges, that would not change the moral case one iota. To kill many billions of these animals on these grounds is to allow the performance of many billions of acts that cause unjustified harm to many billions of animals. But the wrongness of killing a single animal does not depend on the wrongness of killing many. The third objection claims that a crucial factor has been systematically ignored. There are a lot of hamburgers, steaks, roasts, and so on that come out of a single cow, for example. So there are a lot of people, not just a single individual, who will be called upon to forego a lot of good eating and culinary rewards if we give up eating and cooking meat. Add up their total of harms, and that total greatly exceeds anything the cow has been made to endure. So, the objection concludes, the cow loses after all. That single animal is not being made worse off. This objection assumes that people would be harmed by foregoing the pleasant taste of meat and the challenge to cook it well, assumptions that, for reasons offered earlier, are dubious at best. More fundamentally, the objection assumes that we can justify imposing a prima facie greater harm on a given individual if the aggregate of the lesser harms done to others happens to outweigh the total harm done to that individual. The rights view categorically denies the propriety of this approach. To override the rights of individuals on the grounds of such aggregative computations is to treat that individual as a mere receptacle of value, something that, on the rights view, such individuals as cows are not. The totem of utilitarian theory, summing the consequences for all those affected by the outcome, is the taboo of the rights view. Nutrition and habit. There is no question that meat is a nutritious food. In particular, it is a source of complete protein, containing all the amino acids essential for human health and vitality. If it were true that these nutrients were not otherwise obtainable, then the case for eating meat, even given the right's view, would be on solid ground. If we were certain to ruin our health by being vegetarians, or run a serious risk of doing so, as 4 previously contends, and given that the deterioration of our health would deprive us of a greater variety and number of opportunities for satisfaction than those within the range of farm animals, then we would be making ourselves, not the animals, worse off if we became vegetarians. Thus might we appeal to the liberty principle as a basis for eating meat, assuming the other provisos of that principle were satisfied. To concede the necessity of meat in a healthy diet is to concede more than is meat's due. The essential amino acids are essential, that is true, but there are alternative ways to obtain them, ways that do not rely on meat. To protest that the kind of knowledge required to combine incomplete proteins to yield complete proteins exceeds the grasp of the consumer's limited intelligence, and that therefore the meat industry serves the interests of public health, is patronizing in the extreme. It should be especially demeaning to any female homemaker with the slightest feminist tendencies, since such an attitude helps perpetuate and intensify the myth of the dumb housewife, someone who not only doesn't now know but lacks the intellect to learn the difference between, say, a fat and a carbohydrate. Certain amino acids are essential for our health. Meat isn't. We cannot, therefore, defend meat eating on the grounds that we will ruin our health if we don't eat it, or even that we will run a very serious risk of doing so if we abstain. Any risk we run can be easily overcome by taking the modest trouble required to do so. Habit and convenience. The defense of meat eating based on habit and convenience, 3 previously, is glaringly deficient. That we are in the habit of doing something, or that we find it convenient to do it, goes no way toward justifying the morality of what we do when our habits or the convenience of indulging them support a practice that harms other innocent individuals. Singer's observations about racism, sexism, and speciesism have a place in this regard. That certain people once were, or for that matter, still are in the habit of discounting the equal moral standing of women or the members of minority races tells us something about the psyches of these people. It does not tell us anything about the justice of their acting from the habits that they have. If, in response to arguments that challenge the justice of racial or sexual discrimination, we are told that it is convenient for the racist or sexist to discount the relevance or importance of the harm done to those who belong to the wrong race or sex, our reply should be that questions of just treatment are not decided by the criterion of personal or group convenience. According to the rights view, the treatment of animals should not and cannot reasonably be assessed any differently. Valid appeals to the liberty principle assume that all involved are treated with respect, something we would fail to do if we overrode the rights of farm animals by appeals to our habits concerning what we eat, or the convenience of doing so. Besides, there already are many convenience items that are both nutritious and meatless, and tasty. Economic considerations. When we turn to economic considerations, critics may claim that the case against vegetarianism comes into plain view, given 2 of the principles the rights view advances. First, the worse-off principle, and second, the liberty principle. Let us postpone examining the putative role of this latter principle until the conclusion of the present section and concentrate initially on the worse-off principle. The farmer, it might be claimed, 5 earlier, will be made worse off relative to the animals he raises if we, the consumers, became vegetarians and thereby failed to support him. After all, he would lose his financial shirt, and with this loss, the harm done to him would outweigh any harm any one animal raised by farmers, even one raised in close confinement, is called upon to endure. Moreover, since the rights view prohibits aggregating the lesser prima facie harms of the many as a way to justify causing greater prima facie harm to the few, the rights view cannot allow aggregating the lesser prima facie harms of the animals in this case. We ought to continue eating meat, it might be claimed, not, to be sure, because we happen to like its taste or because we are in the habit of eating it, but because we owe it to the farmer not to make him worse off, which is what we would do if we stopped buying his products. We will, it is true, continue to have the benefits of pleasant-tasting meat dishes, as well as the convenience associated with eating meat. But far from resting the defense of meat eating on anything so flimsy as our personal preferences or habits, we may now take the moral high road. Those who eat meat are merely fulfilling their duty to the farmer to do so. How adequate is this defense of meat eating? Does it, that is, succeed in offering a defense validated by the worse-off principle? It does not. Recall that the worse-off principle includes the proviso about special considerations. As was explained in an earlier discussion of this notion, some special considerations involve acquired duties, for example, the duty to keep a promise, while others involve voluntary participation in activities wherein the participants waive their right not to be made worse off as a result of participating in these activities. For example, those who voluntarily participate in a high-risk activity, such as hang gliding or mountain climbing, waive this right in the ways explained earlier, and that is one of the risks they run. Voluntary participation in competitive activities is similar. In a marathon, the victory goes to the one who runs the full course and crosses the finish line first. Justice is done when that runner is awarded the prize, assuming that the other runners were not themselves unfairly hindered in their progress on the course. The victor is not to be decided by asking which runner would be made worse off if he did not win. That would make running the race pointless. Indeed, it would make the event something other than a competitive race. The runner who would be made worse off if he fails to win deserves no more consideration than any other competitor, nor any less. He cannot claim the prize as being his due by appeal to how not getting it will affect his welfare. Voluntarily to enter the competition is to acknowledge that considerations about who will be made worse off are suspended in this case, and anyone who entered the race and did not understand or acknowledge this would not understand what a competitive race is and would not belong in one. What is true of road racing is true of any competitive activity, including voluntary participation in any business activity, including raising animals as a business venture. To enter this or any other business not only is to run the risk of not winning, of not making a financial success of one's undertaking, it is also tacitly to acknowledge both that no one, whether business competitor or consumer, has a duty to purchase one's products or services, and that such purchase cannot be claimed as one's due. A business person who would be made worse off if her products or services were not purchased has no valid claim on anyone to make the necessary purchases to keep her business afloat. Like road racing, competitive business is an activity where those who voluntarily participate must understand that the worse-off principle is suspended, and anyone who professes not to understand this does not understand what being in business is. We do not, therefore, owe it to any farmer who sells meat to purchase his products, and neither do we owe it to anyone else in the animal industry, those who run the packing houses, the processors and packagers, the wholesalers, deliverers, the retailers, and the like, to buy anything they produce or sell, and none of them has a valid claim against us to do so. What we do owe them is the same equal respect we owe to others. We do not owe them more than this, and it would be to give them more than is their due if we supposed that we owed it to them to purchase their products so that they will not be made worse off relative to the animals they harm. The worse-off principle is suspended when persons voluntarily engage in competitive activities, something any businessman or woman should well understand. On the rights view, numbers make no difference in such a case, and neither does the sum of the harms of those who lose out in the competition. If not one farmer, but thousands would be made worse off by our refusing to buy their products, that would not make any moral difference. And if not just these farmers, but the others mentioned earlier, for example, meat processors, would join the farmers in their failure, that too would not alter the moral assessment on the rights view. The sum of their losses, however great, would not give rise to any obligation to buy any of their products. Perhaps it will be objected that the dependents of those in the meat industry will be made worse off than any animal is made by that industry if we all became vegetarians. Moreover, since these dependents have not themselves chosen to take a competitive place in this business, their right not to be made worse off is not suspended in the way that the right of those who voluntarily choose to compete is. Thus, it might be argued, we have a duty to continue to purchase meat, not because we happen to enjoy its taste or find its use convenient, and not because we owe it to those in the business to buy it, but because we owe it to the dependents of those involved in the animal industry to do what we must to ensure that they are not the ones who are made worse off. Now, it is true that some individuals do have the responsibility to protect the dependents of those in this industry from being made worse off if that industry should happen to collapse in general, or if this or that farm, packing house, or butcher shop should fail. But it is not the consumers, in their capacity as consumers, who have this responsibility. Fundamentally, it is those very persons on whom these dependents are dependent, namely, those who voluntarily choose to compete in the market in meat, who are responsible to their dependents to do all that justice allows to protect them in the event that the business fails. Since having acquired duties is a legitimate special consideration for choosing to spare causing significant harm to those to whom one has these duties, even though someone else will thereby be made worse off, someone's having these duties to others makes that person's moral responsibility to these individuals greater than those who lack these acquired duties. Those to whom one has acquired duties, after all, acquire additional rights. To allow acquired duties to count as special considerations in some cases, but to deny that those who have these duties have greater moral responsibility to those to whom they have them than do others, would be palpably inequitable. It is those in the meat industry, not consumers then, who must bear greater responsibility to ensure that their dependents, for example their children, are not made worse off if this industry or some part of it fails. Consumers do not owe it to any animal farmer, meat packer, and the like to buy the products of their labor so that his kith and kin will not be made worse off than any animal harmed by the animal industry. He owes it to them to do what must be done to prevent this from happening in the event that his business fails or his job is lost, assuming that the steps he takes are just and that he is not himself unjustly prevented from taking them. Those who must bear the principal responsibility for the personal losses associated with a business's failure are those whose business it is. The rights view is not antagonistic to business, free enterprise, the market mechanism, and the like. What the rights view is antagonistic to is the view that consumers owe it to any business to purchase that business's goods or services. The animal industry is no exception. Nor is the rights view antagonistic to respecting and enforcing just agreements voluntarily reached that would serve to protect those whose businesses fail, or those who lose their jobs because of this, or the dependents in either case. Insurance policies that protect those who own and run a business, unemployment benefits due union members, programs designed to equip persons with new skills, and kindred measures are permissible, according to the rights view, so long as they do not violate the rights of others. Moreover, because everyone who runs a business or assumes a job runs some risk of losing it, and because some who have acquired duties to their dependents are woefully lax in discharging them, everyone, including those involved in the meat industry and those who oppose it, ought to recognize the reasonableness of joining in common cause to help those who will be most directly affected, small farmers and meat packers, for example, as advocates of the rights view increase in numbers and influence. Granted, the threat to the animal industry posed by this movement may today be viewed as the least of that industry's worries. Nevertheless, for those involved in that industry to minimize the potential of this threat would be for them to run the risk of not preparing for the impact of an idea whose time has come. A common argument urged against recognition of the rights of farm animals takes the following form. Since these animals would not exist except for the economic interest the farmer has in raising them, his economic interests should determine how they ought to be treated. If, then, the intensive rearing of farm animals serves the farmer's economic interests, factory farming is justified. The harm done to these animals is, as it were, the price they pay for having that share of existence that falls their way because of the decisions and interests of the farmer. This argument assumes that those agents who are causally responsible for bringing about a given individual's existence are sovereigns over that individual once that individual exists, the treatment due that individual to be determined by the interests of those who arrange for his or her existence in the first place. This assumption lacks any claim to credibility. My son would not now exist except for the past decisions and acts of my wife and myself. In that sense, he owes his existence to us. But it does not follow from this that once he has come to be, we, his parents, are thereby entitled to do just anything to him we like. Once he has himself become the subject of a life that fares better or worse for him, logically independently of us, there are strict moral restrictions, grounded in the recognition of his inherent value, that we must respect if we are to treat him as justice requires. We are not his moral sovereigns. The case of farm animals does not differ in any morally relevant way. Once any given animal has become the subject of a life that fares better or worse for her, the same principles of just treatment apply. If the farmer were to protest that it was not for the purpose of just treatment that he brought the animal into existence in the first place, we would be entitled to reply that that makes no moral difference. Once he has such an animal in his care, his past motives and intentions for arranging for the animal to come to be simply do not override the right of the animal to treatment consistent with and required by the respect to which she is due. Voluntarily to arrange for the coming to be of farm animals is voluntarily to acquire duties to these animals one would not otherwise have, whether that was one's intention or motive for arranging for their coming to be or not. Viewed from the perspective of the rights view, farmers assume moral burdens when they allow their animals to breed or purchase animals from others who do, just as, analogously, parents assume moral burdens by having or adopting children. One's intentions or motives for having or adopting children, whatever they might be, no more give one a moral license to harm them than the motives and intentions of farmers give them license to harm the animals in their care. That the farmer is of a different opinion shows only how far he is from the recognition of the rights of animals, not that these animals have no rights to be recognized. This argument, as well as the one below that addresses the idea of animals as legal property, can be used to respond to popular defenses of the human right to use laboratory animals as we choose. I shall not repeat it in the later discussion of that use of animals. A final consideration relates the farmer's economic interests to the liberty principle. Even if it is true that we have no duty to purchase the farmer's products, and even granting that we cannot defend our own consumption of meat by appeal to the worse-off principle, still, it might be claimed, the farmer operates within his rights by raising animals for food. Since he would be worse off if he did not raise them, it is permissible for him to do so, despite the harm done to animals. This appeal to the liberty principle neglects a crucial proviso of that principle, namely, provided that all those involved are treated with respect. This is a requirement that the present practice of raising farm animals for human consumption, whether this is done in factory farms or humanely, fails to meet. A practice, institution, enterprise, or similar undertaking is unjust if it permits or requires treating individuals with inherent value as if they were renewable resources, and such individuals are treated as if they were such resources if, before they have reached a state or condition where terminating their life can be defended on grounds of preference respecting or paternalistic euthanasia, they are killed, their place to be filled by another, similar individual whose life will be similarly terminated, and so on. Such an institution is unjust, according to the rights view, because it requires treatment that violates the respect principle, requiring, as it does, that individuals with inherent value are to be treated as if they lacked any independent value of their own, and instead had value only relative to the interests of those who engage in the practice or to the preferences of those who support it. Such a practice treats these individuals as renewable because it treats them as replaceable without any prima facie wrong having been done to those who were killed, and as resources because what value they are assumed to have is viewed as being contingent upon their utility relative to the interests of others. But individuals who have inherent value are not renewable resources and are not to be treated as if they were. They have a kind of value that is distinct from and is not reducible to their utility relative to the interests of others, and they are always to be treated in ways that show respect for their independent value, not out of kindness or compassion, but as a matter of strict justice. Any practice, institution, or other undertaking that permits or requires treating individuals with inherent value as if they were renewable resources, therefore, permits or requires treatment of these individuals that violates the respect principle. As such, the treatment the practice sanctions and the practice itself are unjust. This verdict of the rights view is reached independently of considerations of the pain or suffering caused to those individuals who are treated as renewable resources, though what pain or suffering they are caused compounds the wrong. It is the impoverished view of the value of these individuals, not only the pain or suffering they are made to endure, that exposes the practice as fundamentally unjust. Even were the individuals who were treated as renewable resources, in the sense explained, treated well, for example, not caused unnecessary suffering, that would not alter the basic injustice of the practice. It would only eliminate the further wrong of harming these individuals in this way. It would make the implementation of the practice less wrong, but it would not remove the fundamental injustice endemic to the practice. The grounds for finding unjust any practice that treats individuals who have inherent value as renewable resources are distinct from considerations about the consequences of such a practice. The rights view's position is not that such a practice must or is likely to lead to less than the best aggregate consequences for all those affected by the outcome. The value of the consequences that such a practice will or is likely to give rise to is irrelevant to finding such a practice unjust. Even were the consequences the best that could be obtained, such a practice remains unjust because it continues to permit or require treating individuals with inherent value in ways that are inconsistent with the respect they are due. The grounds for judging such a practice unjust also are distinct from judging acts or practices wrong because they treat individuals with inherent value as mere receptacles. To treat such individuals as mere receptacles is wrong because unjust, and it is unjust because it fails to treat them with the respect they are due. But to treat such individuals as mere receptacles at least has one advantage over treating them as renewable resources. When treated as mere receptacles, their goods, for example, their pleasures, and their harms, for example, pains, are viewed as being directly morally relevant to the determination of what ought to be done. It just so happens that when viewed in this way, the harm done to them can be justified by appeals to the best aggregate consequences. When individuals are treated as renewable resources, however, their goods and their harms can have no direct moral significance. What significance they have, if they have any, is contingent upon what is in the interests of those who treat them as renewable resources. To view individuals with inherent value as renewable resources, thus, is to view them as even less than mere receptacles. Since, on the rights view, it is unjust, because disrespectful, to treat them as if they were mere receptacles, it is an even greater injustice to treat them as if they were even less than this. Farm animals raised for human consumption are today treated as renewable resources, and this is a verdict we reach whether these animals are raised in close confinement or humanely. These animals are routinely killed well in advance of their having reached a state or condition where taking their life could plausibly be viewed as an act of mercy. Their place in the production line is taken by other animals, who will in time be killed well in advance of their having reached a state or condition where taking their life could plausibly be viewed as an act of mercy, and then others will replace them, and so on, as the system perpetuates itself. Beyond any question, these animals are viewed and treated as renewable or replaceable. That they are viewed and treated as resources, having value only relative to the interests of others, also is true. The moral significance of what harms or benefits these animals is measured by the interests of those who raise them. If hogs are harmed when raised in close confinement, that does not compute morally if a close confinement system advances the interests of the farmer. If beef cattle are harmed by having their life brought to an untimely end, that does not register morally if this practice furthers the interests of the cattle rancher. In saying this, one is not saying that those involved in animal agriculture are cruel people who like nothing better than to torture their animals. For why this is inappropriate, see 6.1. It is to make the simple point that these animals are treated as resources, their harms and benefits acquiring moral significance only if or as these relate to the interests of the farmer. If keeping animals unhealthy were economically advantageous, modern agriculture would doubtless find a way to do this. Indeed, it already has. Witness the veal calf. To treat farm animals as renewable resources is to fail to treat them with the respect they are due as possessors of inherent value. It is, then, to treat them unjustly, and this finding makes all the moral difference in the world when, as we are supposing, the farmer claims that he is within his rights in raising these animals for human consumption. He would be within his rights, given the liberty principle, only if those who are harmed by what he does, namely the animals he raises, were treated with respect. But they are not treated with respect and cannot be so long as they are treated as if they are renewable resources. This is why, on the rights view, farmers who raise animals for human consumption are engaged in an unjust practice. Morally, they exceed their rights. Morally, this practice ought to cease, and consumers ought to cease to support it. Even if it were true, which it is not, that consumers would be made worse off relative to the condition of farm animals if they stopped buying meat, it would not follow that consumers act within their rights when, by choosing to buy meat, they choose to support the practice that allows and requires this treatment. Consumers would be acting within their rights only if this practice treated animals with the respect they are due, since, for the reasons given, the current practice of raising farm animals for human consumption fails to treat these animals with respect. Those who support this practice by buying meat exceed their rights. Their purchase makes them a party to the perpetuation of an unjust practice. Vegetarianism is not supererogatory, it is obligatory. Here it will be protested, point 6 from earlier, that it is not just the economic interests of the farmers, meat packers, wholesalers, and the like that are at stake. The economy of the nation is directly tied to the maintenance and growth of the meat industry. To cease purchasing the products of this industry would bring about economic calamity, affecting the welfare of millions upon millions of people, many of whom, through no fault of their own, and without having voluntarily run the risks associated with participation in the meat industry, will be made worse off. It is in order to avoid this catastrophe that we ought to continue to buy meat. The rights view denies this defensive support of the meat industry. Just as the benefits others obtain as a result of an unjust institution or practice is no moral defense of that practice or institution, so the harms others might face as a result of the dissolution of this practice or institution is no defense of allowing it to continue. Put alternatively, no one has a right to be protected against being harmed if the protection in question involves violating the rights of others. Since, for reasons given in the preceding, the practice of raising farm animals, as presently conducted, routinely treats these animals in ways that are contrary to the respect they are due as a matter of strict justice, that practice violates the rights of these animals. As such, no one, neither those directly involved in the meat industry nor those who would be affected by its collapse, has a right to be protected against being harmed by allowing that industry to continue. In this sense, and for these reasons, the rights view implies that justice must be done, though the economic heavens fall. It is, of course, extremely unlikely that the economic heavens will fall. We are not likely to awake tomorrow to discover that, overnight, everyone has been converted to vegetarianism, a development that precipitates the total and instantaneous collapse of the meat industry and the economic gloom such a collapse conceivably might bring. The scenario sketched 2 paragraphs back, therefore, is most improbable. The dissolution of the meat industry as we know it will come incrementally, not all at once, and the economy of the nation and the world will have time to adjust to the change in dietary lifestyles. Nevertheless, the essential moral point remains. No one has a right to be protected by the continuation of an unjust practice, one that violates the rights of others. And this is true whether one actively participates in this practice or, though not an active participant, benefits from it and would be harmed by its discontinuance. Vegetarians who would be harmed by the total and instantaneous collapse of the meat industry would have no more right to complain of the injustice done to them than would meat eaters. Since no injustice would be done to them were that industry to dissolve, even the veggies could have no grounds for complaint. Animals as legal property. At this point, if not before, the charge, point 7 from earlier, will be made that farmers own animals, that farm animals are their legal property, and that this makes all the difference. Just as the color I paint the walls of my house or my decision to sell it are my own affairs because the house is my property, so it may be argued what the farmer does to his animals is his own affair, since they are his property. And just as anyone who would deny me the right to paint my walls or to sell my house if I am so inclined would be unjustifiably overriding my property rights, so the attempt to limit how the farmer treats his animals is unjustifiably to override his property rights. 2 responses to this line of argument will have to suffice. First, granted that the present legal status of farm animals is that they are property, and even assuming that their legal status as property is not changed, it does not follow that legal constraints placed on how animals may be treated necessarily violate farmers' property rights. Property rights are not absolute. While what color I choose to paint my walls is my affair, what I choose to do with my property is not my affair alone, if what I do with it will have an adverse effect on others. Living as I do in a suburban subdivision, I am not at liberty to turn my house into an adult bookstore, a gambling casino, a house of ill repute, or even a 7-Eleven. The property rights, not to mention the other rights my neighbors will have, impose limits on what I may do with my property. There is no reason why the treatment of animals, even assuming that they are and will continue to be viewed as legal property, should be otherwise. If, as has been argued at length in the preceding, animals have basic moral rights, then these rights ought to be recognized as imposing strict constraints on what any farmer may be allowed to do to them in the name of exercising his property rights. That is one reform in the law on the rights view that must come, and that, assuming enough are committed to the cause, will come. Second, and more fundamentally, The very notion that farm animals should continue to be viewed as legal property must be challenged. To view them in this way implies that we cannot make sense of viewing them as legal persons, but the history of the law shows only too well, and too painfully, how arbitrary the law can be on this crucial matter. Those humans who were slaves were not recognized as legal persons in pre-Civil War America. There is no reason to assume that because animals are not presently accorded this status, that they cannot intelligibly be viewed in this way, or that they should not be. If our predecessors had made this same assumption in the case of human slaves, the legal status of these human beings would have remained unchanged. Only one response to the call to recognize animals as legal persons will be considered here. One can anticipate the following, said by those whose present livelihood is tied to the animal industry. They might argue that if farm animals were no longer viewed as property, farmers would no longer have sufficient economic incentive or legal protection to raise them. And if that were so, these farmers would look elsewhere than the animal industry as a source of reliable income, with the result that there would be fewer farm animals. And this, it might be claimed, shows how counterproductive the rights view is. That view, it may be argued, aspires to protect farm animals, but its ultimate result, if it were to succeed, is that there would no longer be farms where animals are raised for commercial profit. And what kind of protection can that be if the very creatures one aspires to protect are no longer around to be protected? This response assumes that the ultimate goal of the rights view, when applied to farm animals, is somehow self-defeating. But this is a product of confusion. It is true, and the point bears emphasis, that the ultimate objective of the rights view is the total dissolution of the animal industry as we know it, an objective that should hardly be surprising, given the rights view's verdict that, as presently conducted, this industry violates the rights of farm animals. But this view does not call for the extinction of farm animals, only that those there are be treated as justice requires. If no economically profitable venture could meet this requirement, then that incentive for continuing to have these animals on Earth will be missing. But since it is this very incentive that lies behind viewing these animals as renewable resources, and that gives rise to the violation of their rights, its absence should be a cause for celebration rather than regret. Moreover, despite depressing evidence to the contrary, human beings sometimes are motivated to act for other than economic reasons, and there is no reason to assume that if the day comes when people no longer have an economic interest in raising farm animals, none of these animals will be around. There will be fewer, that much is certain, but that will be an index of our moral progress, not our moral failure. The rights view never claims, and does not imply, that the quality of the life of individual farm animals is logically or causally tied to there being vast numbers of them. This is not true in the case of the quality of life of individual human beings. There is no reason to judge the case of animals any differently. Finally, it will be protested, point 8 from earlier, that some farm animals, most notably chickens and turkeys, are not mammals, and so, given the rights view's position regarding those animals who are subject of a life, fall outside the scope of the principles prescribed by this view. Poultry farmers then, so it may be alleged, avoid the condemnation of the rights view, even if it is true that other farmers do not. This defense of the poultry industry fails to take into account how difficult it is to draw the line between animals who do and those who do not satisfy the subject of a life criterion, and fails, moreover, to place the justification of poultry farming within the larger context of our culture's habits of treating all farm animals as renewable resources. These are common deficiencies shared by those who, for example, defend the use of non-mammalian animals in science or their harvest in hunting. In order to avoid repeating the main tenets of the rights view's response to arguments of this kind, a reply to this defense of poultry farming will be deferred until an analogous response is given to those who defend using non-mammalian animals in science. Vegetarianism, utilitarianism, and animal rights. The fundamental difference between the moral basis of vegetarianism offered by the rights view and the one offered by utilitarianism should now be clear. Assuming that the interests, the preferences or pleasures, of all those affected by the outcome of an action or rule have been taken into account, and assuming that equal interests have been counted equally, justice has been done according to utilitarianism, and the significant harm done to any one individual is not unjust if causing it is necessary to bring about the optimal aggregate balance of goods, for example, pleasures, over evils, for example, pains, for all those affected by the outcome. For the utilitarian, therefore, it is an open moral question whether the harm done to farm animals, even the harm they are made to bear in factory farms, is justifiable. If the aggregated consequences turn out to be optimal, then the harm is justified. The utilitarian's case against the harm done to farm animals cannot be any stronger than how convincingly he shows that the facts are against allowing it. To meet this challenge, the utilitarian must have the relevant facts at hand, and this means he must tell us, 1, what the consequences are, all considered, for all those affected by the outcome of the harm done to farm animals, as well as what the balance of goods, for example, preference satisfactions over evils, for example, preference frustrations, are. 2, what the consequences would be, all considered, for all those affected by the outcome if we were all to become vegetarians, either all at once or gradually. And 3, whether, when everything is taken into account, these latter consequences would be better than the former. It is not unfair to the utilitarian basis for the obligatoriness of vegetarianism to remind ourselves that the facts necessary for resting this obligation on utilitarian considerations simply are not at hand. Judged by its own standards, in short, the utilitarian basis for vegetarianism is far from compelling. Recall, finally, that the rightness of my refusal to buy meat depends, for the utilitarian, not on what I do, but on how many others do the same thing. For it is only if enough others abstain, and only if this number reduces how many farm animals are harmed, or how much harm is done to them, that, according to utilitarian thought, I do what is right. Though it is impossible to know the minds of all, it is unlikely that those who are not already committed to utilitarianism believe that the principle of utility does justice to their thought about why vegetarianism is obligatory. The rights view succeeds where utilitarianism fails. My acting as duty requires does not depend on how many others act similarly, and no vegetarian should be deterred from his or her course because of the many who continue to support the animal industry, or because it is uncertain whether, and if so, when and how one individual's abstention makes a difference. For example, to how many animals are thereby spared the abuse of factory farming. The individual is right not to purchase the products of an industry that violates the rights of others, independently of how many others act similarly, and the case against the animal industry does not stand or fall, according to the rights view, on that individual's knowing, or on any individual's knowing, the aggregate balance of goods over evil for all those affected by allowing factory farming or by not allowing it. Since the industry routinely violates the rights of these animals, for the reasons given, it is wrong to purchase its products. That is why, on the rights view, vegetarianism is morally obligatory, and why, on that view, we should not be satisfied with anything less than the total dissolution of commercial animal agriculture as we know it, whether modern factory farms or otherwise. Life on the lifeboat. A critic of the rights view might challenge this view by deploying a variant of the lifeboat case discussed earlier. Recall the situation. There are 5 survivors, 4 normal adult human beings and a dog. The boat will support only 4. All will perish if one is not sacrificed. Which one ought to be cast overboard? The rights view's answer is the dog. The magnitude of the harm that death is, it has been argued, is a function of the number and variety of opportunities for satisfaction it forecloses for a given individual, and it is not speciesist to claim that the death of any of these humans would be a prima facie greater harm in their case than the harm death would be in the case of the dog. Indeed, numbers make no difference in this case. 1 million dogs ought to be cast overboard if that is necessary to save the 4 normal humans. The aggregate of the lesser harms of the individual animals, harming no one in a way that is prima facie comparable to the harm death would be to any of these humans. But suppose, a critic may conjecture, it is not a question of having enough room on the boat. Imagine it is a question of which individual to eat if 4 others are to survive. Who should be eaten? The rights view's answer, once again, is the dog. And it is the dog who should be eaten because the harm that death is in the case of that animal is not as great a harm as the harm that death would be in the case of any of these humans. In lifeboat cases, in short, the obligation to be vegetarian can be justifiably overridden, according to the rights view. The survivors would be acting within their rights, justified by appeal to the liberty principle, if they chose to kill and eat the dog in these dire circumstances. Any one of them might, it is true, choose not to do this, choosing to sacrifice his own life rather than to be a party to killing the animal. But that would be something that, on the rights view, is not obligatory. That would be supererogatory. Our imagined critic might suppose that the rights view's assessment of the lifeboat case undermines that view's case against the current practice of animal agriculture. But this is not true, for at least 3 different reasons. First, stationed in the world as we are not in the situation of the survivors in the lifeboat. They have, we are assuming, no other option than to eat meat if they are to stay alive and well. We do. To concede that the obligation to be vegetarian is overridable in dire circumstances, such as those on the lifeboat, therefore, is not to imply that its obligatoriness wanes for us in our day-to-day existence. Second, and relatedly, what a theory implies ought to be done in exceptional cases, and the lifeboat case is an exceptional case, cannot be fairly generalized to apply to unexceptional cases. One cannot, then, argue that since the rights view implies that those humans on the lifeboat would be justified in eating the dog, the rights view implies that we are justified in gorging ourselves at the neighborhood pig pickin'. That would be analogous to supposing that if a view allows that we would be justified in killing someone intent upon killing us, it must also imply that we would be justified in killing just anyone we had a mind to. No one would, or should, be tempted to suppose that a view that allows one to kill in self-defense must imply this. It is to be hoped that no one would, or should, suppose that the rights view's verdict concerning who should be eaten on the lifeboat is a license to give in to a Big Mac attack. Third, what a view implies may be done in isolated, exceptional circumstances does not commit it to taking a similar view of practices or institutions. Granted, the survivors on the lifeboat would be justified in eating the dog in order to avoid being made worse off. Still, it does not follow that hog farmers, for example, do no wrong in raising pigs in order that they may avoid being made worse off. Isolated, exceptional cases, such as the lifeboat case, are not practices or institutions, and the judgment one makes about the former is not automatically transferable to the latter, though in exceptional circumstances we are justified in limiting an individual's liberty. Say a man has become temporarily deranged and poses a threat to the security of others, a threat we can cancel only by forcibly restraining him. It does not follow that we would be justified in allowing institutions or practices that routinely limit individual liberty, that is, that limit individual liberty in unexceptional, ordinary circumstances. The justice of a practice or institution is not shown in this way. Its justice is shown by whether all those involved are treated with the respect they are due. Because the practice of animal agriculture as we know it fails to treat farm animals with the respect they are due, that practice is unjust. What is permissible on the lifeboat makes no moral difference to what is permissible on a hog farm, unless the hog farmer be tempted to escape this implication and the general implications of the rights view by seeking refuge in utilitarian theory. It is good to remind him that utilitarianism fails to provide adequate moral protection for human beings, himself included. The dissolution of commercial animal farming as we know it obviously requires more than our individual commitment to vegetarianism. To refuse on principle to buy the products of the meat industry is to do what is right, but it is not to do enough. To recognize the rights of animals is to recognize the related duty to defend them against those who violate their rights, and to discharge this duty requires more than our individual abstention. It requires acting to bring about those changes that are necessary if the rights of these animals are not to be violated. Fundamentally, then, it requires a commitment to contribute to the revolution in our culture's thought about and in its accepted treatment of farm animals. Mill's words are again apposite. Recall his observing that when an individual has a valid claim and thus a right to something, society ought to defend that individual in the possession of that right, either by the force of law or by that of education or opinion. Our challenge, then, may be conceived in these terms: to help to educate those who presently support the animal industry to the implications of their support, to help to forge the opinion that this industry, as we know it, violates the rights of farm animals, and to work to bring the force of law, if necessary, to bear on this industry to effect the necessary changes. That is no small challenge, to be sure, but to reach the goal of justice for these animals requires nothing less. Merely to content oneself with personal abstention is to become part of the problem rather than part of the solution. 9.2. Why hunting and trapping are wrong. Since animals can pose innocent threats, and because we are sometimes justified in overriding their rights when they do, one cannot assume that all hunting or trapping must be wrong. If rabid foxes have bitten some children and are known to be in the neighboring woods, and if the circumstances of their lives assure future attacks if nothing is done, then the rights view sanctions nullifying the threat posed by these animals. When we turn from cases where we protect ourselves against the innocent threats wild animals pose, to the activities of hunting and trapping, whether for commercial profit or sport, the rights view takes a dim view indeed. Standard justifications of the sport of hunting, that those who engage in it get exercise, take pleasure in communion with nature, enjoy the camaraderie of their friends, or take satisfaction in a shot well aimed, are lame given the rights view. All these pleasures are obtainable by engaging in activities that do not result in killing any animal. Walking through the woods with friends and a camera substitutes nicely. And the aggregate of the pleasures hunters derive from hunting could only override the rights of these animals if we viewed them as mere receptacles, which, on the rights view, they are not. The appeal to tradition, an appeal one finds, for example, in support of fox hunting in Great Britain, has no more force in the case of hunting than it does in the case of any other customary abuse of animals, or humans. All that appeals to tradition signal in this case, and all they signify in related contexts, is that it is traditional to view animals as mere receptacles, or as renewable resources. These appeals to tradition, in other words, are themselves symptomatic of an impoverished view of the value animals have in their own right, and thus can play no legitimate role in defending a practice that harms them. Such appeals are as deficient in Great Britain, when made in behalf of the sport of fox hunting, as they are when made in Japan or Russia in defense of commercial whaling, or in Canada in defense of the annual slaughter of seals. To allow these practices to continue if certain quotas are not exceeded is wrong, given the rights view, for reasons that will become clearer as we proceed. Of course, those who hunt and trap sometimes rest their case on other considerations. It is not their pleasure that justifies what they do. Rather, it is the humane service they perform for the animals that does. The situation, we are enjoined to believe, is this. If a certain number of animals are not hunted or trapped, there will be too many animals belonging to a given species for a given habitat to support. That being so, some of these animals will die of starvation because of their inability to compete successfully with the other animals in the habitat. To cull or harvest a certain number of these animals, thus, has the humane purpose and achieves the humane goal of sparing these animals the ordeal of death by starvation. How can the rights view, or any other view that is sensitive to the welfare of animals, find fault with that? The rights view finds fault with this defense of hunting and trapping on several counts. First, the defense assumes that the death endured by hunted and trapped animals is always better, that is, always involves less suffering, than the death these animals would endure as a result of starvation. This is far from credible. Not all hunters are expert shots, and not all trappers tend their traps responsibly or use traps that exhibit their humane concern for animals, the infamous leg-hold trap being perhaps the most notorious example to the contrary. Is it obvious that animals who experience a slow, agonizing death as a result of a hunter's poor shot or a poorly tended trap have a better death than those who die from starvation? One looks for an argument here and finds none. Unless, or until one does, the defense of hunting and trapping on the grounds that they kill more humanely is specious. Second, appeals to humane concern are dramatically at odds with the philosophy of current hunting and trapping practices, as well as with wildlife management generally. This philosophy, or the creed of maximum sustainable yield, applies to hunting and trapping in the following way. Those who hunt and trap are legally permitted, within specified seasons, to harvest or crop a certain number of wildlife of various species. The quota for that season, both collectively and for each individual hunter, to be fixed by determining whether, together with the best estimates of natural mortality, those who hunt and trap will be able to harvest the same number next season, and the next, and so on. In this way, the maximum sustainable yield is established. If this philosophy is applied successfully, hunters and trappers will be legally licensed to do the same thing in future seasons as others were licensed to do in the past, namely, kill up to a certain number, a certain quota, of animals. If, that is, restraint is exercised in each season, the total number of animals that can be harvested over time will be larger, or to put the point in its simplest, starkest terms, if fewer animals are killed now, future generations of hunters will be able to kill a larger aggregate number of animals in the future, which will be better. This implication of the creed of maximum sustainable yield unmasks the rhetoric about humane service to animals. It must be a perverse distortion of the ideal of humane service to accept or engage in practices the explicit goal of which is to ensure that there will be a larger, rather than a smaller, number of animals to kill. With humane friends like that, wild animals certainly do not need any enemies. Essentially, the same point can be made regarding the aggregate amount of suffering animals will endure if the creed of maximum sustainable yield is successful. If successful, the total number of animals who will die an agonizing death as a result of the poor shooting of hunters, plus those who die in similar agony as a result of poorly tended humane traps, plus those who die by natural causes, will be larger than if other options were adopted. It is a moral smokescreen, therefore, to defend sport hunting and trapping by appeal to their humane service. The actions allowed by the philosophy of maximum sustainable yield speak louder than the lofty words uttered in its defense. The success of this philosophy would guarantee that more, not fewer, animals will be killed, and that more, not fewer, animals will die horrible deaths, either at the hands of humans or in the course of nature. But it is not only the inconsistency between what it proclaims and what it implies that marks the undoing of the creed of maximum sustainable yield. That approach to decision-making regarding wildlife management policies profoundly fails to recognize or respect the rights of wild animals. No approach to wildlife can be morally acceptable if it assumes that policy decisions should be made on the basis of aggregating harms and benefits. In particular, these decisions should not be made by appeal to the minimize harm principle. That principle sets before us what seems to be a laudatory goal, namely to minimize the total amount of harm in general and suffering in particular. But that principle lacks the moral wherewithal to place any limits on how this laudatory goal is to be achieved. It lacks the means to assess the means used to achieve this end. If the rights of individuals are violated, that simply does not compute morally, given the minimize harm principle, if violating these rights is instrumental in achieving the goal of minimizing total harm. The rights view categorically denies the propriety of this approach to decision-making. Policies that lessen the total amount of harm at the cost of violating the rights of individuals, whether these individuals are moral agents or patients, and if the latter, human or animal, are wrong. Even if it were true, which it is not, that the philosophy of maximum sustainable yield would lead to a reduction in the total amount of death and suffering for undomesticated animals, it still would not follow that we should accept that philosophy. As it systematically ignores the rights of wild animals, so does it systematically violate them. The rights view categorically condemns sport hunting and trapping. Though those who participate in it need not be cruel or evil people, recall the earlier discussion of cruelty in 6.1, what they do is wrong. And what they do is wrong because they are parties to a practice that treats animals as if they were a naturally recurring renewable resource, the value of which is to be measured by and managed by reference to human recreational, gustatory, aesthetic, social, and other interests. Animals do renew themselves. Normally, they do not require human assistance to reproduce, any more than do trees, for example. But wild animals are not natural resources here for us. They have value apart from human interests, and their value is not reducible to their utility relative to our interests. To make a sport of hunting or trapping them is to do what is wrong, because it is to fail to treat them with the respect they are due as a matter of strict justice. Shorn of their appeal to their humane concern for wildlife, defenders of hunting and trapping are likely to protest that what they do is no different in kind from what other animals do in the state of nature. Animals routinely kill members of other, though only infrequently members of their own, species, and the death they suffer at the hands of other animals is gruesome enough to make even the most hardened heart wince. When it comes to interspecies relations, nature is red in tooth and claw. If the rights view professes to condemn sport hunting and trapping, it might be claimed, then it should do the same when it comes to the fatal interaction between animals themselves. The rights view rejects this argument. Animals are not moral agents, and so can have none of the same duties moral agents have, including the duty to respect the rights of other animals. The wolves who eat the caribou do no moral wrong, though the harm they cause is real enough. So it is that, according to the rights view, the overarching goal of wildlife management should not be to ensure maximum sustainable yield. It should be to protect wild animals from those who would violate their rights, namely sport hunters and trappers, commercial developers who destroy or despoil their natural habitat in the name of economic interest, and the like. It is, in short, human wrongs that need managing, not the crop of animals. Put affirmatively, the goal of wildlife management should be to defend wild animals in the possession of their rights, providing them with the opportunity to live their own life by their own lights as best they can, spared that human predation that goes by the name of sport. We owe this to wild animals not out of kindness, nor because we are against cruelty, but out of respect for their rights. If, in reply, we are told that respecting the rights of animals in the wild in the way the rights view requires does not guarantee that we will minimize the total amount of suffering wild animals will suffer over time, our reply should be that this cannot be the overarching goal of wildlife management once we take the rights of animals seriously. The total amount of suffering animals cause one another in the wild is not the concern of morally enlightened wildlife management. Being neither the accountants nor managers of felicity in nature, Wildlife managers should be principally concerned with letting animals be, keeping human predators out of their affairs, allowing these other nations to carve out their own destiny. When we move from sport to the commercial exploitation of wildlife, the moral scene is the same, only worse because the number of animals involved is greater. The rights view condemns the business of killing wild animals. Even if it is true that those whose present quality of life is tied to commerce in wild animals would be made worse off if their business failed, that is no reason why we should continue to allow it. Like anyone who enters the world of business, those whose business it is to kill wild animals must understand that they waive their right not to be made worse off if their business fails. We have no duty to buy their products, and they have no right to require that we keep either their business or their present quality of life afloat. To appeal to the risk of diminished welfare in the case of their dependents is as lame in the present case as it was in the case of animal agriculture as a defense in support of those whose business it is to kill wild animals. Moreover, while those in this business, like the rest of us, have the right to do what they can to avoid being made worse off, they, like the rest of us, exceed this right when what they do violates the rights of others. And the commercial exploitation of wildlife does this with a vengeance. Animals in the wild are treated as renewable resources, as if they had value only relative to the economic interests of those who feed off their dead carcasses. The rights view categorically condemns the commercial harvesting of wild animals, not because those embarked on this business are or must be cruel or evil people, but because what they do is wrong. Justice will be done when and only when we refuse to allow these commercial ventures to continue. One can imagine someone accepting the letter but not the spirit of the foregoing. For there are, after all, many non-humans who are killed, either for sport or commerce, who are not animals in the limited sense in which this word has been used throughout this and earlier chapters, who are not, that is, normal mammalian animals aged 1 year or more. A voice might be heard in support of duck hunting, for example, or in defense of the commercial exploitation of baby seals. Because similar protests might be raised in different contexts. For example, one might claim that what one does to non-mammalian animals in science or to poultry in agriculture should not be covered by the same principles that apply to what is done to mammals. A review of this defense of hunting and trapping will be deferred until later. Here it will suffice to raise a simple question. Let us assume that newly born wild mammalian animals, for example baby seals, do not yet meet the subject of a life criterion. Still, they clearly have the potential to do so. Why then should the moral standards that apply to how they may be treated differ in any way from those that apply to how human infants should be? The rights view denies that there is a non-arbitrary difference one could cite to justify treating the two differently. Unless one would be willing to approve of harming human infants in pursuit of sport or profit, one cannot approve of the similar treatment of infant mammalian animals. No even partial assessment of hunting and trapping could be adequate if it failed to mention the matter of predator control. Sheep farmers in the southwestern United States, for example, are troubled by predatory animals, most notably coyotes, who attack grazing sheep, sometimes killing more than they need to subsist. The economic loss suffered by these farmers occasions their public outcry, and they have taken steps, with the assistance of federal funds and personnel, to control these predators. Those who accept the rights view must work to bring an end to such predator control programs. The official justification of these programs assumes that the predators cause losses to persons engaged in a justified enterprise, namely the animal industry. Since the rights view denies that this industry's treatment of animals is morally justified, the harm done to predatory animals in the name of minimizing the financial losses of those engaged in this industry is morally to be condemned. In the struggle between those involved in the animal industry and those predatory animals who inhabit the lands used in the name of this industry, it is the industry, not the predators, that ought to go. And if in response those in the industry appeal to their legal rights to the land and their legal ownership of the animals in their business, those who accept the rights view should reply, first, that the appeal to legal rights by itself never settles any moral question, and second, that the present legal status of farm animals as owned property is itself one of the traditions the rights view seeks to change. 9.3. How to worry about endangered species. The rights view is a view about the moral rights of individuals. Species are not individuals, and the rights view does not recognize the moral rights of species to anything, including survival. What it recognizes is the prima facie right of individuals not to be harmed, and thus the prima facie right of individuals not to be killed. That an individual animal is among the last remaining members of a species confers no further right on that animal, and its right not to be harmed must be weighed equitably with the rights of any others who have this right. If, in a prevention situation, we had to choose between saving the last two members of an endangered species or saving another individual who belonged to a species that was plentiful, but whose death would be a greater prima facie harm to that individual than the harm that death would be to the two, then the rights view requires that we save that individual. Moreover, numbers make no difference in such a case. If the choice were between saving the last 1,000 or million members of a species to which the two belong, that would make no moral difference. The aggregate of their lesser harms does not harm any individual in a way that is prima facie comparable to the harm that would be done to this solitary individual. Nor would aggregating the losses of other interested parties, for example, human aesthetic or scientific interests, make any difference. The sum of these losses harms no individual in a way that is prima facie comparable to the harm that would be done to the single individual if we chose to override his right. The rights view is not opposed to efforts to save endangered species. It only insists that we be clear about the reasons for doing so. On the rights view, the reason we ought to save the members of endangered species of animals is not because the species is endangered, but because the individual animals have valid claims, and thus rights against those who would destroy their natural habitat, for example, or who would make a living off their dead carcasses through poaching and traffic in exotic animals, practices that unjustifiably override the rights of these animals. But though the rights view must look with favor on any attempt to protect the rights of any animal, and so supports efforts to protect the members of endangered species, these very efforts, aimed specifically at protecting the members of species that are endangered, can foster a mentality that is antagonistic to the implications of the rights view. If people are encouraged to believe that the harm done to animals matters morally only when these animals belong to endangered species, then these same people will be encouraged to regard the harm done to other animals as morally acceptable. In this way, people may be encouraged to believe that, for example, the trapping of plentiful animals raises no serious moral question, whereas the trapping of rare animals does. This is not what the rights view implies. The mere size of the relative population of the species to which a given animal belongs makes no moral difference to the grounds for attributing rights to that individual animal, or to the basis for determining when that animal's rights may be justifiably overridden or protected. Though said before, it bears repeating, the rights view is not indifferent to efforts to save endangered species. It supports these efforts. It supports them, however, not because these animals are few in number. Primarily, it supports them because they are equal in value to all who have inherent value, ourselves included, sharing with us the fundamental right to be treated with respect. Since they are not mere receptacles or renewable resources placed here for our use, the harm done to them as individuals cannot be justified merely by aggregating the disparate benefits derived by commercial developers, poachers, and other interested third parties. That is what makes the commercial exploitation of endangered species wrong, not that the species are endangered. On the rights view, the same principles apply to the moral assessment of rare or endangered animals as apply to those that are plentiful, and the same principles apply whether the animals in question are wild or domesticated. The rights view does not deny, nor is it antagonistic to recognizing, the importance of human aesthetic, scientific, sacramental, and other interests in rare and endangered species, or in wild animals generally. What it denies is that 1. The value of these animals is reducible to, or is interchangeable with, the aggregate satisfaction of these human interests, and that 2. The determination of how these animals should be treated, including whether they should be saved in preference to more plentiful animals, is to be fixed by the yardstick of such human interests, either taken individually or aggregatively. Both points cut both ways, concerning as they do both how animals may and how they may not be treated. In particular, any and all harm done to rare or endangered animals, done in the name of aggregated human interests, is wrong, according to the rights view, because it violates the individual animal's right to respectful treatment. With regard to wild animals, the general policy recommended by the rights view is, let them be, since this will require increased human intervention in human practices that threaten rare or endangered species, for example, halting the destruction of natural habitat and closer surveillance of poaching, with much stiffer fines and longer prison sentences. The rights view sanctions this intervention, assuming that those humans involved are treated with the respect they are due. Too little is not enough. Rights and environmental ethics. An aside. The difficulties and implications of developing a rights-based environmental ethic, alluded to in an earlier context, should be abundantly clear by now and deserve brief comment before moving on. The difficulties include reconciling the individualistic nature of moral rights with the more holistic view of nature emphasized by many of the leading environmental thinkers. Aldo Leopold is illustrative of this latter tendency. A thing is right, he states, when it tends to preserve the integrity, stability, and beauty of the biotic community. It is wrong when it tends otherwise. The implications of this view include the clear prospect that the individual may be sacrificed for the greater biotic good in the name of the integrity, stability, and beauty of the biotic community. It is difficult to see how the notion of the rights of the individual could find a home within a view that emotive connotations to one side might be fairly dubbed environmental fascism. To use Leopold's telling phrase, man is only a member of the biotic team, and as such has the same moral standing as any other member of the team. If, to take an extreme, fanciful, but it is hoped not unfair example, the situation we faced was either to kill a rare wildflower or a plentiful human being, and if the wildflower, as a team member, would contribute more to the integrity, stability, and beauty of the biotic community than the human, then presumably we would not be doing wrong if we killed the human and saved the wildflower. The rights view cannot abide this position, not because the rights view categorically denies that inanimate objects can have rights, more on this momentarily, but because it denies the propriety of deciding what should be done to individuals who have rights by appealing to aggregative considerations, including, therefore, computations about what will or will not maximally contribute to the integrity, stability, and beauty of the biotic community. Individual rights are not to be outweighed by such considerations, which is not to say that they are never to be outweighed. Environmental fascism and the rights view are like oil and water. They don't mix. The rights view does not deny the possibility that collections or systems of natural objects might have inherent value, that is, might have a kind of value that is not the same as, is not reducible to, and is incommensurate with any one individual's pleasures, preference satisfactions, and the like, or with the sum of such goods for any number of individuals. The beauty of an undisturbed, ecologically balanced forest, for example, might be conceived to have value of this kind. The point is certainly arguable. What is far from certain is how moral rights could be meaningfully attributed to the collection of trees or the ecosystem. Since neither is an individual, it is unclear how the notion of moral rights can be meaningfully applied. Perhaps this difficulty can be surmounted. It is fair to say, however, that no one writing in this important area of ethics has yet done so. Because paradigmatic right holders are individuals, and because the dominant thrust of contemporary environmental efforts, for example, wilderness preservation, is to focus on the whole rather than on the part, that is, the individual, there is an understandable reluctance on the part of environmentalists to take rights seriously, or at least a reluctance to take them as seriously as the rights view contends we should. But this may be a case of environmentalists not seeing the forest for the trees, or more accurately, of not seeing the trees for the forest. The implications of the successful development of a rights-based environmental ethic, one that made the case that individual inanimate natural objects, for example, this redwood, have inherent value and a basic moral right to treatment respectful of that value, should be welcomed by environmentalists. If individual trees have inherent value, they have a kind of value that is not the same as, is not reducible to, and is incommensurate with the intrinsic values of the pleasures, preference satisfactions, and the like of others. And since the rights of the individual never are to be overridden merely on the grounds of aggregating such values for all those affected by the outcome, a rights-based environmental ethic would bar the door to those who would uproot wilderness in the name of human progress, whether this progress be aggregated economic, educational, recreational, or other human interests. On the rights view, assuming this could be successfully extended to inanimate natural objects, our general policy regarding wilderness would be precisely what the preservationists want, namely, let it be. Before those who favor such preservation dismiss the rights view in favor of the holistic view more commonly voiced in environmental circles, they might think twice about the implications of the two. There is the danger that the baby will be thrown out with the bathwater. A rights-based environmental ethic remains a live option, one that, though far from being established, merits continued exploration. It ought not to be dismissed out of hand by environmentalists as being in principle antagonistic to the goals for which they work. It isn't. Were we to show proper respect for the rights of the individuals who make up the biotic community, would not the community be preserved? And is not that what the more holistic, systems-minded environmentalists want? 9.4. Against the use of animals in science. Debates over the use of animals for scientific purposes have traditionally been waged in terms of being for or against vivisection, but this term, vivisection, is ill-suited for our purposes. To vivisect an animal is to dissect it, to cut it while it is alive. Not all practices that demand our attention involve vivisection. There are three major areas of science in which animals are routinely used. These are 1. Biological and medical education, 2. Toxicology testing, where the potential harmful effects for human beings of new products and drugs are first tested on animals, and 3. Original and applied research, including not only research into the causes and treatments of various diseases, but also into the basic biochemical nature and behavior of living organisms. All of us are familiar with the use of animals in education from our time spent in laboratory sections in biology, for example, and most of us have an outsider's inkling of what goes on in original and applied research from what we read in the newspapers and are exposed to by the other media. As for the use of animals in toxicity testing, that will become clearer below when we discuss various toxicity tests, including the so-called LD50 test. It is possible that some people might object to including all three uses of animals under the general heading of the use of animals in science. In particular, some scientists might have a narrower view of science, according to which only original and applied research count as genuine science. The use of animals in educational contexts or in toxicological testing isn't science on this view, or not real science at any rate. This narrower conception of science is understandable if science is viewed exclusively in terms of devising and testing original hypotheses. The fact remains, however, that it is not by witchcraft or astrology, say, that the toxicity of pesticides, food additives, hairsprays, and oven cleaners is determined. It is a matter of applied science. And it is not to turn out persons educated in, say, philology or accounting that lab sections are held in connection with standard courses in biology. It is to educate persons in biological science. So while there may be a sense in which neither toxicity tests nor instructional labs are science, there is certainly another sense in which they are a recognized part of those activities carried on by scientists in their capacity as scientists or as teachers of science. For these reasons, then, to inquire into the morality of how animals are used in science or for scientific purposes requires assessing their use in all three areas: in biological and medical education, in toxicology testing, and in original and applied research. Each area will be considered in the order just given. The use of animals in educational settings. Animals of many kinds and descriptions are used in a variety of ways in educational settings, including science fairs, standard laboratory sections for high school and university courses in biology, zoology, and related disciplines, in student-conducted research projects, in practice surgery in both medical and veterinary schools. The list goes on. Nothing approaching a complete examination of the many uses is possible. By concentrating on one use, namely the dissection of live animals in high school and university lab sections, what the rights view's position would be regarding these remaining uses should be clear enough not to require separate treatment, especially in light of this view's position about the use of animals in toxicology and research. As farm and wild animals are not to be viewed as mere receptacles or renewable resources whose rights can be overridden on the basis of aggregating human benefits, so mammalian laboratory animals are not to be viewed in these ways. The acquisition of knowledge is a good thing, but the value of knowledge does not by itself justify harming others, the less so when this knowledge is obtainable by other means. In the case of knowledge of the anatomy and physiology of mammalian animals studied in lab sections in high school and university biology, zoology, and related courses, this knowledge is obtainable without relying on hands-on experience. Students do not need to dissect any known animals to learn facts about their anatomy and physiology. Detailed drawings of animal anatomy and physiology exist in abundance and are usually included in the very texts used in such courses. On the rights view, to continue to include standard lab sections involving dissection of live mammalian animals is as unnecessary as it is unjustified. 3 objections can be anticipated. The first claims that, while these facts can be obtained without dissecting any live animal, the experience of dissecting cannot be had by this means. That experience can only be had by dissecting. This is true, but not to the point. Morally, one cannot justify doing something merely on the grounds that one cannot have the experience of doing it without doing it. If that were sufficient, one could justify doing anything and everything from rape to murder. For it is only if I participate in a rape or if I murder someone that I can have the experience of doing so. The general point is the simple one, namely that to justify doing something, one has to justify what one does independently of pointing out that one could not experience it without doing it. Thus, while it is true that students could not have the experience of dissecting a live animal without dissecting one, that fact by itself goes no way toward justifying their doing it, let alone requiring that they do it. One must ask whether there are any reasons for viewing what is done as wrong or as not wrong, and this will involve asking whether the value of having the experience is sufficient to justify doing what is necessary to have it. The rights view holds that reasons against doing it outweigh the reasons for. Since dissecting a live mammalian animal harms that animal, frequently causing it pain, and customarily being a prelude to that animal's untimely death, to defend dissection by appeal to the value of the experience of dissecting commits one to viewing these animals as if they were mere receptacles or renewable resources, a profound mistake according to the rights view. It is wrong because unjust to dissect living animals so one can have the experience of dissecting. 2. In reply, the following might be urged. Even granting that the harm done to mammalian animals in lab sections is unjustified, most of the animals used in such courses are not mammals. Now, since on the rights view, non-mammalian animals are not claimed to be the subjects of a life, in the sense in which this notion is understood by the rights view, the proponents of that view should have no principled objection to the use of these animals. The rights view's response begins by noting that even if non-mammalian animals are not the subjects of a life in the sense explained, it is possible that many of these animals are conscious and capable of experiencing pain. As has been conceded on more than one occasion in the above, where one draws the line regarding the presence of consciousness is in some ways analogous to where one draws the line in other cases. For example, how tall one has to be tall, or how old one must be old. There is no precise height or exact age one must be tall or old respectively, but there are clear cases nonetheless. Similarly, it may not be possible to say with anything approaching certitude whether a given individual is or is not conscious or does not experience pain, despite the fact that there are clear cases where individuals are conscious and sentient. But though analogous in some respects, the two cases differ in others. Normally, nothing of moral significance turns on whether an individual is tall or is old. A great deal that is morally significant turns on whether an individual is conscious and can experience pain. Because we are uncertain where the boundaries of consciousness lie, it is not unreasonable to advocate a policy that bespeaks moral caution. Such a policy would have us act as if non-mammalian animals are conscious and are capable of experiencing pain unless a convincing case can be made to the contrary. In the absence of the case to the contrary, that is, it is not unreasonable to advocate a policy that gives the benefit of the doubt to animals that, though not mammals, nevertheless share relevant anatomical and physiological properties with mammalian animals, for example, a central nervous system. The adoption of this policy would make a significant difference to whether we should permit or require dissection of live, unanesthetized animals that are relevantly like paradigm-conscious beings. If we give these animals the benefit of the doubt, we will operate on the assumption that these animals are conscious and do experience pain. And if we operate on that assumption, we will view dissection, when they are unanesthetized, as causing them pain and thus as standing in need of moral defense. That defense is not supplied by pointing to the knowledge gained. Since this knowledge is obtainable without causing pain to anyone, the presumptive pain caused those animals to whom we have given the benefit of the doubt, caused in the name of acquiring knowledge, is morally too great. Nor is the required justification supplied by alluding to the value of having the experience of dissecting, when this causes presumptive pain, since that experience can be had without risking causing any pain. Without the use of anesthetics, the policy of giving these animals the benefit of the doubt assumes that the animals are caused pain, and pain that is unnecessary. To require or allow students to dissect lower animals without the use of anesthetics is morally unjustified. But what of cases where lower animals are anesthetized? The same considerations apply. Though non-mammalian animals differ from us anatomically and physiologically in some respects, they resemble us in others, and it may be that the resemblance in some cases are more important than the differences. We simply do not know enough to justify dismissing out of hand the idea that a frog, say, may be the subject of a life, replete with desires, goals, beliefs, intentions, and the like. When our ignorance is so great and the possible moral price so large, it is not unreasonable to give these animals the benefit of the doubt, treating them as if they are subjects, due our respectful treatment, especially when doing so causes no harm to us. Adoption of this policy would make a difference, one that taking care to administer anesthesia to frogs, say, would not fully accommodate. For since the untimely death of an animal who is the subject of a life harms the animal, the routine death caused those animals in lab sections becomes morally relevant. If we are genuinely to give the frog the benefit of the doubt, we will not only take care to spare frogs unnecessary pain by using anesthesia, we will also take care not to kill them or allow them to die unnecessarily. We will, that is, not use them for purposes of dissection. 3. A critic might protest that frogs just aren't worth giving the benefit of the doubt to, claiming that stirring our conscience over the remote possibility that frogs have rights is to carry things too far. Let us, then, this critic maintains, prohibit use of mammalian animals, but allow unlimited use of those who are not mammals, though with the recommendation that anesthesia be used. This reply occasions the third point. What transpires in, say, a biology lab doesn't occur in a vacuum. It is both an effect and a contributing cause of prevailing cultural beliefs, attitudes, and traditions about non-humans. The acquisition of these beliefs and attitudes and the introduction into these traditions are part of our acculturation. The rights view has implications that challenge some of these beliefs, attitudes, and traditions. It rejects the view that mammalian animals, at least, are mere receptacles or convenient renewable resources, and affirms that they have a value of their own, independent of human interests. Now, the cultural acceptance of the rights view obviously, in part, turns on how well it is received and transmitted in our culture's system of education, including courses in science. Indeed, it is these courses, more than any others, that have the greatest potential to encourage cultural acceptance of the rights view. Pedagogically, how might this potential be developed most fully? Not by continuing to require students to dissect living animals, whether anesthetized or not, and whether mammalian or not, especially when the knowledge gained is obtainable without doing this. To require this is to help encourage the belief that non-human animals don't count morally, a belief that the dominant cultural influences outside the lab encourage enough without the need of any further assistance. Outside the lab is the world of Big Macs, Kentucky Fried Chicken, the weekend hunting trip, commercial whaling, fur coats, rodeos, cockfights, animal shelters, all symptoms of our culture's throwaway attitude toward animals, as if these sensitive creatures were commodities or things. To require students to dissect animals, when the knowledge acquired can be gained without doing this, is to feed into this throwaway attitude. To cease to require this is to take an important step in the opposite direction. A variant of Kant's psychological speculations is apt in this regard. Kant's position, it will be recalled, is that cruelty to animals ought to be discouraged, not because we owe it to animals themselves not to be cruel to them, but because people who are cruel to animals develop habits of cruelty that in time lead them to maltreat human beings. However likely Kant's speculation about the connection between cruelty to animals and cruelty to human beings might be, it is more likely that requiring students to treat some animals as if they were of no direct moral significance will encourage them to form this habit of thought and action toward animals generally, the more so given that the dominant cultural influences already are heavily inclined in this direction. Even if it is true, then, that the animals most frequently dissected in high school and university lab sections lack rights, to continue to require dissecting them is likely to help foster habits that will lead persons to engage in practices that violate the rights of those animals who do have them, or to acquiesce by supporting those who do so. One way, and this is a not unimportant way, to check the development of these habits is to cease to require students to dissect any animal, explaining that the knowledge acquired by doing it is obtainable without doing it, and pointing out that the sciences of biology, zoology, and the like do not take the view that the animals they study are so insignificant, so valueless, that they may be dissected and disposed of when it is unnecessary to do this. Considerations analogous to 2 and 3 above form part of the basis of the rights view's case against treating chickens and turkeys as if they are renewable resources. These judgments are unlikely to meet with much enthusiasm on the part of some of those who teach high school and university courses in the life sciences. Like academicians generally, they will treasure their academic freedom, and rightly so. To challenge what they require or permit in their laboratories is likely to be viewed as an invasion of this freedom. We don't tell philosophers how they should teach their courses, it may be said, so philosophers shouldn't tell us how we ought to teach ours. The point is well taken, up to a point. Philosophers obviously are not in a position to select what text should be used in science courses, or what scientific ideas should be stressed, or in what order these ideas should be presented. Nothing said previously implies otherwise. What a philosopher may legitimately do is challenge common practices on moral grounds, with reasons that do not require expertise in one or another scientific discipline. And scientists can do the same if they find practices in the classrooms of philosophy that they consider morally objectionable. It is the soundness of the moral arguments given, not who gives them, that should be decisive. The preceding attempts to show how, by relying on the rights view, a commonly accepted practice in scientific education can be challenged. Reasons for accepting the rights view have been set forth at length in the preceding chapters. If that view has reason on its side, and if its application in the present case is sound, then lab sections that require or permit dissection of live animals ought to cease. For teachers to call a halt to this customary part of our education in the life sciences would not be to abdicate their academic freedom, it would be to exercise it. Toxicology. Animals are routinely used to test for the possible toxicological, literally poisonous, threat posed by a variety of commercially manufactured items intended primarily for human use or consumption. Two kinds of substances are tested: therapeutic and non-therapeutic. The former are drugs that may alleviate or cure pathological conditions, for example, gout, ulcers, high blood pressure. The class of non-therapeutic products includes everything else. The following is a representative list of non-therapeutic products tested for toxicity: insecticides, pesticides, antifreeze chemicals, brake fluids, bleaches, Christmas tree sprays, church candles, silver cleaners, oven cleaners, deodorants, skin fresheners, baby preparations, bubble baths, freckle creams, depilatories, eye makeup, crayons, fire extinguishers, inks, suntan oils, nail polish, mascara, hairsprays and rinses, zipper lubricants, paints, thermometers, and children's novelties. For simplicity's sake, therapeutic items will normally be referred to simply as drugs, while non-therapeutic items will be referred to as products. Kinds of toxicity tests. Dallas Pratt, an American medical doctor, offers the following definition of a toxic substance. A substance is defined as toxic if, when eaten, inhaled, or absorbed through the skin, it causes by its chemical action either damage to structure or disturbance of function, or both. Standard test procedures include 1. Acute toxicity, 2. Subacute toxicity, and 3. Chronic toxicity. Acute toxicity tests Pratt characterizes as a search for untoward reaction at a high dose level, while subacute tests, in general, define the biological activity of a compound, an estimate of the no-effect dosage, and the maximum tolerated dosage. The latter tests are generally conducted over a 3-month period. The former take a shorter amount of time. The long-term, small-dosage toxic effects of a substance are assessed in chronic toxicity tests that normally take about 2 years. Carcinogenicity tests on animals fall in this last category. In addition, there are other standard tests for some products, for example, cosmetics, including eye and skin irritancy tests. The number of animals used in toxicity tests in the United States is unknown, but using available British statistics, Pratt estimates that about 20% of his estimate of 100 million animals used for scientific purposes in this country are used in toxicology. That works out to about 20 million animals. Among the common signs of a substance's toxic effects on test animals, Pratt lists the following: unusual vocalization, restlessness, twitch, tremor, paralysis convulsions, rigidity, flaccidity, salivation, lacrimation, swelling of sex organs and breasts, skin eruptions, discharge including hemorrhage from the eye, nose, or mouth, unusual posture, emaciation. Toxicity tests, in short, harm animals not only if and when they cause them acute or chronic suffering or distress, but also because they deprive them of opportunities for obtaining the satisfactions their capacities make available to them. Animals who are paralyzed may not be in pain, but that does not mean they are not thereby harmed. A number of books have chronicled these tests at length. We will have to be content with a slightly fuller description of only one test, the acute toxicity test known as the LD50 test. No one can improve on the description Singer gives. The standard test for toxicity, or the extent to which a substance is poisonous, is the lethal dosage 50 test, commonly abbreviated to LD50. The aim of this test is to determine the dosage level at which 50% of the test animals will die. Usually this means that all the animals will become very sick before half finally succumb and the other half survive. In the case of fairly harmless substances, it is still considered good procedure to find the concentration that will make half the animals die. Consequently, enormous quantities have to be force-fed to the animals, and death may be caused merely by the large volume or high concentration given to the animals. It is also normal to let the process of poisoning take its full course until death occurs. To put dying animals out of their misery might give a slightly inaccurate result. Similarly, to be discouraged, for similar reasons, is the use of anesthesia in standard toxicity tests. The effects of the anesthetic might give a slightly inaccurate result. The information obtained from LD50 tests forms the background basis for the danger, poison, warning, and caution labels on many products. The legal requirement to perform particular tests, such as the LD50, is murky at best in the case of some products, for example, cosmetics. As Pratt observes, however, even when the test is not mandated by government regulations, it is frequently used by manufacturers of drugs and consumer products on the supposition that it is a protection against proceedings for negligence. With these brief remarks serving as background, let us now turn to the task of morally assessing toxicity tests on animals, beginning first with products. Toxicity tests of products. Animal toxicity tests of products can be, and have been, challenged on the basis of their limited scientific validity. The problem of extrapolating test results from animals to humans is notorious. For example, some products, for example benzene and arsenic, have no discernible toxicological effect on test animals and yet are highly toxic for human beings. Why this is so is not clear, but test results have been shown to vary depending on the time of day the test was performed, what the animals ate, and other subtle variables. Moreover, since much already has been learned about the toxicity of strong acids and alkaloids, new products that contain either are known to be highly toxic for humans before conducting any further test, while others, such as many cosmetics, because they contain chemicals known to be benign, are known to be non-toxic without additional testing. In such cases, the tests can be disputed on the grounds that they are unnecessary. Both these ways of attacking toxicology tests of products on animals can create the unintended, and from the rights view's perspective, the unwarranted impression that toxicity tests on animals would be morally acceptable if only the unnecessary tests were eliminated, or if only the problem of extrapolation could be surmounted. On this latter point, those who conduct and support such tests, acknowledging the present limitations, could argue that the very unreliability of present tests justifies conducting further tests in order to overcome the shortcomings of existing methods. And if those who would defend laboratory animals were to object that these present scientific liabilities cannot be overcome, they would be accused, and rightly so, of prejudging a very complicated scientific question in advance, without adequate knowledge, and in a way that invites and deserves the charge of being anti-scientific. The reasons one must mount against such tests, if one is to defend laboratory animals, cannot be confined to citing some blatantly unnecessary tests, though such tests there are, or to exposing the stark deficiencies of the methodology as presently applied, though the exposure is deserved. The very institution of administering these tests must be attacked at its moral foundations. How might someone attempt to justify these tests, given the principles identified and defended by the rights view? The following line of argument seems the most plausible by far. If new products were introduced into the market without having pre-tested their toxicity by using animals, the risks of harm humans would run would be greatly increased, and the harms in question would be prima facie greater than the harm done to any test animal. For example, use of a hairspray might cause blindness, or inhalation of an untested oven cleaner might cause incapacitating respiratory defects, either of which would make a human being worse off than any test animal. Moreover, since, according to the rights view, the aggregate of lesser harms does not harm any particular individual, we cannot add up the lesser harms done to the test animals and suppose that we arrive at a greater harm than, say, the harm that blindness is for a human. What we must do in order to minimize the risk that a human will be made worse off by using a product that turns out to be toxic for humans is pre-test for toxicity by using animals. The rights view attacks this defense on two main grounds. The first contests the permissibility of placing animals at risk of harm or harming them in order to identify or reduce the risks that humans would run if they use something new. Since this argument applies to any toxicity test carried out for this purpose, not just to tests on new products, a statement in defense of this argument will be postponed until toxicity tests of new drugs are examined. The second group applies specifically to testing new products for their toxicity by using animals. It begins by noting that the defense of these tests, offered by appeal to the worse-off principle, assumes that pre-market toxicity tests that harm animals can be justified by appealing to what might happen after new products are marketed if these pre-market tests were not performed. But morality does not work in the way this defense assumes it does. After the mine cave-in has occurred, to refer back to that earlier example, I am justified in saving the 50, even though this will cause certain death to the one miner, but it does not follow from this that I would have been justified in causing the mine cave-in in the first place. Analogously, even if it were true that employing harmful toxicity tests on animals could be justified by appealing to what might happen assuming a product is already on the market, it would not follow that the decision to develop and market the product is justified. In this latter case, what is wanted is a moral justification for developing the product in the first place, a justification that, in the nature of the case, cannot be given by appealing to the harm that might happen after the product already has been introduced. Now, the very principle, the worse-off principle, to which manufacturers are most likely to appeal in an effort to defend these tests, shows that these tests are unjustified. The defense of this claim begins by noting that there already are plenty of lipsticks, eyeshadows, oven cleaners, paints, brake fluids, crayons, and other products competing in the market and readily available to consumers. There is no demonstrable human need that would be served by having new products from which to choose, excluding, of course, the economic interests of the manufacturers, about which more momentarily. Nor is there any credible basis for believing that any consumer would be harmed by being deprived of yet another Christmas tree spray or nail polish from which to choose, least of all that this deprivation in any given case would be prima facie comparable to the harm done to animals in, say, the LD50 test. Moreover, since the aggregate of these lesser harms endured by consumers, even assuming that consumers would be harmed by being deprived of new products from which to choose, harms no particular individual in a way that is prima facie comparable to the harm done to the test animals. Appeal to the worse-off principle shows not that these tests are justified, but the very reverse. Since the issue is whether the pre-market development of a new product can be justified if it harms animals, and since this is a question about the decision to develop a new product in the first place, the harm that might result after the product has been marketed is irrelevant, just as, analogously, what I would be justified in doing after the mine cave-in is irrelevant to determining whether I would have been justified in causing the cave-in in the first place. The central moral point, then, is this: no consumer will be made worse off than any test animal if no new products are introduced. Assuming, then, that all those involved are treated with respect, and assuming that no special considerations obtain, what we ought to do is not introduce new products if their pre-market development involves making animals worse off relative to any consumer. Rather than justifying harmful toxicity tests on animals, appeal to the worse-off principle shows that they are unjustified. The economic interests of those involved in businesses that manufacture these products may be cited as a reason for allowing toxicity tests on animals. The rights view denies the moral relevance of these considerations when questions about overriding basic moral rights are at issue. Even if it were true that those involved in the cosmetic industry, for example, would lose some future profits when barred from doing toxicity tests on animals, that would make no moral difference. First, because their loss of profits would not represent a harm that is prima facie comparable to the harm done to the test animals, and second, even if it were true that someone involved in this industry would be harmed in ways that are prima facie comparable to the harm done to these animals, indeed, even assuming this individual was made worse off relative to the condition of the animals, that would not justify continued use of these tests. Those who voluntarily participate in a business venture voluntarily take certain risks, including the risk that they might be made worse off if their business fails. Thus, even if someone involved in, say, the cosmetic industry would be made worse off if toxicity tests of cosmetics on animals ceased, that would not justify their continued use. Harmful toxicity tests of products on animals are wrong, then, according to the rights view, not because they are an unreliable means for assessing what is toxic for humans, though the limitations of these tests relative to establishing what is safe for humans are real enough. Nor are they wrong only when, because the results are predictable before the tests are done, certain tests are unnecessary, though this is true also. Fundamentally, these tests are wrong because they violate the rights of laboratory animals, since the only humans who might claim, however implausibly, that they would be made worse off if these tests were not done, namely those associated with the manufacture of new products, are the very ones who voluntarily waive their right not to be made worse off as a result of their voluntary participation in a relevant business venture. And since no consumer would be made worse off than any of the test animals if these tests were stopped and consumers were deprived of new products, appeal to the worse-off principle shows that these tests are morally unjustified. These harmful tests violate the basic moral right of these animals not to be harmed. Morally, they ought to cease. The rights view is not anti-consumer or anti-worker protection. It is not opposed in principle to efforts to minimize the health risks individuals run in the work and marketplace. Consumer and worker safety is a laudatory aim, and human nature being what it is, perhaps it is not unreasonable for society to impose regulations on manufacturers whose products are intended for the public's use, in the hope of protecting the public against unscrupulous businesses out to make a quick buck at the public's expense. What the rights view opposes is practices that violate the basic rights of individuals in the name of the public interest. Toxicity tests of new products that harm animals fall into this category. Anyone who objected to the rights view on the grounds that it is morally indefensible to release untested products into the market would miss the central point. What is morally indefensible is to rely on tests that violate anyone's rights. The options, then, are not either to continue to use these tests or to release untested products. A third option is not to allow products on the market if they were pre-tested for toxicity on animals. That is the option those who would dispute the rights view in the way currently under review fail to recognize. The rights view's denunciation of standard toxicity tests on animals is not anti-business. It does not deny any manufacturer the liberty to introduce any new product into the marketplace, to compete with the others already there, and to sink or swim in the waters of free enterprise. All that the rights view denies is that the toxicity of any new product may be pre-tested on animals in ways harmful to them. Non-animal alternatives are not ruled out by the rights view. On the contrary, their development should be encouraged, both on the grounds of the public interest and because of the legitimate legal interests of the manufacturers. Commercial firms should begin to devote their not inconsiderable financial and scientific resources toward the development of such tests. If, in reply, we are told that it is government regulatory agencies, such as the Food and Drug Administration, that require these tests, and that the manufacturers are only doing what the law requires, then the rights view's principal reply is that these regulatory agencies do not require that any new product be produced. To take refuge in what these agencies require neither provides a moral justification for introducing new products nor for testing their toxicity on animals. Moreover, in denouncing the present practice of testing the toxicity of new products on animals, the rights view does not bid cosmetic manufacturers, for example, to remove all their present products from the shelves. The wrong that has been done in the past cannot be undone. The vital point is not to let it continue in the future. Manufacturers can hardly complain that this is anti-business or against the spirit of the free enterprise system. Let those companies competing in the marketplace compete with the products they already have, or, even more in keeping with this economic philosophy, let them outdo one another by developing non-animal alternatives. And as also befits this philosophy, let them labor to have the scientific validity of these tests recognized by the appropriate regulatory agencies. That sort of competition would be a paradigm of the free enterprise system at its finest. In reply, it will be claimed that no valid non-animal alternatives exist. This is false. In the case of cosmetics, for example, the pioneering work of Beauty Without Cruelty demonstrates beyond any reasonable doubt that it is possible to manufacture and market attractive, reliable products whose toxicity for humans has not been pre-tested on animals. Moreover, in areas where no non-animal tests presently exist, there is no reason why they cannot be explored, and to claim in advance that there are none to be found is to be guilty of being just as anti-scientific as some of those who criticize animal toxicity tests. None are so blind as those who will not look. Whether found or not, whether looked for or not, the Rights View's position is uncompromising. Harmful toxicity tests of new products violate the rights of laboratory animals and ought to be stopped. The least we, as consumers, can do to help achieve this goal is henceforth to refuse to buy any new product, including so-called new, improved varieties of old ones, when they hit the market, unless we know that they have not been pre-tested for their toxicity on animals. That is a modest deprivation anyone who respects the rights of these animals ought to be willing to endure. Toxicity tests of new drugs. Someone might accept the preceding critique of toxicity tests on animals in the case of new products and claim that the case of doing such tests on new therapeutic drugs differs in morally relevant respects. No human being will be harmed in a way that is prima facie comparable to the harm caused test animals in an LD50 test, for example, by being deprived of a new brake fluid or paint. Some humans are harmed, however, right now, as a result of a variety of pathological conditions, and many more will be harmed if we fail to investigate the causes, treatments, and cures of these conditions. Indeed, some will today lose their lives as a result of these maladies, and many more will lose theirs in the future if we fail to investigate their causes and cures. Now, one thing we must do, it may be claimed, is reduce the risk that the treatment prescribed for a given malady will make patients worse off than they otherwise would have been, and this will require establishing the toxic properties of each new drug before, not after, humans take them. Thus arises the need to test the toxicity of each new drug on test animals. If we do not test the toxicity of all new drugs on animals, humans who use these drugs will run a much greater risk of being made worse off as a result of using them than they would if these drugs were pre-tested on animals. In the nature of the case, we cannot say which drugs are toxic for humans in advance of conducting tests on animals. If we could, there would be no need to do the test in the first place. Indeed, we cannot even eliminate all risks after the drug has been extensively pre-tested on animals. Thalidomide is a tragic example. The best we can do is minimize the risks humans who use drugs face as best we can, and that requires testing for their toxicity on animals. The Rights View rejects this defense of these tests. Risks are not morally transferable to those who do not voluntarily choose to take them in the way this defense assumes. If I hang glide, then I run certain risks, including the possibility of serious head injury, and I shall certainly, if I am prudent, want to minimize my risks by wearing a protective helmet. You, who do not hang glide, have no duty to agree to serve in tests that establish the safety of various helmet designs so that hang gliders might reduce their risks, and hang gliders, or those who serve the interests of these enthusiasts, would violate your rights if they coerced or forced you to take part in such tests. How much you would be harmed is not decisive. What matters is that you would be put at risk of harm against your will in the name of reducing the risks that others voluntarily undertake and so can voluntarily decide not to undertake by the simple expedient of choosing not to run them in the first place, in this case by choosing not to hang glide. That tests on you would make it possible for those who hang glide to lessen the risk of being made worse off goes no way toward justifying placing you at risk of harm. As hang gliders are the ones who stand to benefit from participation in this sport, they are the ones who must run the risks involved in participating. They may do all that they can to reduce the risks they run, but only so long as they do not coerce others to find out what these risks are or how to reduce them. It would be a mistake to suppose that what is true in the case of high-risk activity is not true in the case of low-risk activity. Whenever I plug in my toaster, take an elevator, drink water from my faucet or from a clear mountain stream, I take some risks, though not of the magnitude of those who, say, skydive or canoe in turbid waters. But even in the case of my voluntarily taking minor risks, others have no duty to volunteer to establish or minimize my risks for me, and anyone who would be made to do this against her will would have her rights unjustifiably overridden. For example, the risks I run when I drive my car could be minimized by the design and manufacture of the most effective seatbelts and the most crash-proof automobile. But it does not follow that anyone else has a duty to take part in crash tests in the name of minimizing my risks, and anyone who was coerced to do so, whether injured or not, would have every reason to claim that her rights had been violated, or, if the test subject is incapable of making the claim, others would have every reason to make this claim on the subject's behalf. No harm done is no defense in circumstances such as these. To minimize the risks humans who use new drugs would run by testing them on animals is morally no different. Anyone who elects to take a drug voluntarily chooses to run certain risks, and the risks we choose to run, or, as in the case of moral patients for whom we choose, the risks we elect to allow them to run are not morally transferable to others. Coercively to harm others or to put others, whether human or animal, at risk of harm in order to identify or minimize the risks of those who voluntarily choose to run them, is to violate the rights of the humans or animals in question. It is not how much the test subjects are harmed, though the greater the harm, the worse the offense. What matters is that they are coercively used to establish or minimize risks for others. To place these animals at risk of harm so that others who voluntarily choose to run certain risks and who thus can voluntarily choose not to run them may minimize the risks they run is to fail to treat the test animals with that respect they are due as possessors of inherent value. As is true of toxicity tests on new products, similar tests of new drugs on animals involve treating them as even less than receptacles, as if their value were reducible to their possible utility relative to the interests of others. In this case, relative to the interests humans who voluntarily take drugs have in minimizing their risks. Laboratory animals, to borrow an apt phrase from the Harvard philosopher Robert Nozick, are distinct individuals who are not resources for others. To utilize them so that we might establish or minimize our risks, especially when it is within our power to decide not to take these risks in the first place, is to treat them as if they were resources for others, most notably for us. And to defend these tests on the grounds that animals sometimes are not harmed is as morally lame as defending fox hunting on the grounds that the fox sometimes gets away. The rights view is not in principle opposed to efforts to minimize the risks involved in taking new drugs. Toxicity tests are acceptable so long as they violate no one's rights. To use human volunteers, persons who do not suffer from a particular malady, but who give their informed consent as a test subject is, though possible, not generally to be encouraged. To tie the progress of pharmacology and related sciences to the availability of healthy, consenting human subjects itself runs significant risks, including the risk that some may use deceptive or coercive means to secure participation. Moreover, few, if any, volunteers from the affluent classes are likely to step forward. The ranks of volunteers would likely be comprised of the poor, the uneducated, and those human moral patients whose relatives lack sufficient sentimental interests to protect them. There is a serious danger that the least powerful will be exploited. More preferable by far is the development of toxicity tests that harm no one. That is, tests that harm neither moral agents nor patients, whether humans or animals. Even at this date, promising alternatives are being developed. To validate them scientifically is no small challenge, but it is the challenge that must be met if we continue to desire or require that new drugs be tested for their toxicity prior to being made available on the market. To test them on healthy human volunteers is dangerous at best. To test them coercively on healthy animals and human moral patients is wrong. The moral alternative that remains is find valid alternatives. A number of objections can be anticipated. One claims that there are risks and then there are risks. If we stop testing new drugs for their toxicity, think of the risks people would run if they took them. Who could say what disastrous consequences would result? The rights view agrees. People would run greater risks if drugs were not pre-tested. But A, the rights view does not oppose all pre-testing, only those tests that coercively utilize some so that others may reduce those risks they may choose to run or choose not to run. And B, those who had the choice to use an untested drug, assuming it was available, could themselves choose not to run the risks associated with taking it by deciding not to take it. Indeed, prudence would dictate acting in this way except in the direst circumstances. Of course, if untested drugs were allowed on the market, and if people acted prudently, sales of new untested drugs would fall off, and we can anticipate that those involved in the pharmaceutical industry, people who, in addition to their chosen vocation of serving the health needs of the public, also have an economic interest in the stability and growth of this industry, might look with disfavor on the implications of the rights view. 4 brief replies must suffice in this regard. First, whatever financial losses these companies might face if they were not permitted to continue to do toxicity tests on animals carry no moral weight, since the question of overriding basic moral rights is at issue. That these companies might lose money if the rights of animals are respected is one of the risks they run. Second, there is mounting evidence that these companies could save rather than lose money if non-animal tests were used. Animals are an expensive proposition. They must be bred or purchased, fed and watered. Their living quarters must be routinely cleaned, their environment controlled, otherwise one runs the scientific risk of an uncontrolled variable, and so forth. This requires employing trained personnel in adequate numbers, as well as a large and continued outpouring of capital for initial construction, expansion, and maintenance. Tissue and cell cultures, for example, are cheaper by far. So the economic interests of commercial pharmaceutical firms are not necessarily at odds with the changes that will have to be made, as the rights of laboratory animals are respected. Third, anyone who defends present toxicological practice merely by claiming that these tests are required by the involved regulatory agencies, for example, the Food and Drug Administration, would miss the essential moral point. Though these agencies have yet to recognize non-animal tests as meeting their regulations, these agencies themselves do not require that any pharmaceutical firm manufacture any new drug. That is a moral decision each company makes on its own and for which each must bear responsibility. Fourth, appeals to what the laws require can have no moral weight if we have good reason to believe that the laws in question are unjust, and we have good reasons in the present case. Laboratory animals are not a resource whose moral status in the world is to serve human interests. Footnote: it is not only in animal farming that animals are treated as renewable resources. The same is true in the case of laboratory animals in general and of their use in toxicity testing in particular. This theme will be developed more fully in the discussion of the use of animals in basic research that follows. End footnote. They are themselves the subjects of a life that fares better or worse for them as individuals, logically independently of any utility they may or may not have relative to the interests of others. They share with us a distinctive kind of value, inherent value, and whatever we do to them must be respectful of this value as a matter of strict justice. To treat them as if their value were reducible to their utility for human interests, even important human interests, is to treat them unjustly. To utilize them so that humans might minimize the risks we voluntarily take and that we can voluntarily decide not to take is to violate their basic moral right to be treated with respect. That the laws require such testing when they do does not show that these tests are morally tolerable. What this shows is that the laws themselves are unjust and ought to be changed. One can also anticipate charges that the right's view is anti-scientific and anti-humanity. This is rhetoric. The right's view is not anti-human. We, as humans, have an equal prima facie right not to be harmed, a right that the right's view seeks to illuminate and defend. But we do not have any right coercively to harm others or to put them at risk of harm so that we might minimize the risks we run as a result of our own voluntary decisions. That violates their rights, and that is one thing no one has a right to do. Nor is the right's view anti-scientific. It places the scientific challenge before pharmacologists and related scientists. Find scientifically valid ways that serve the public interest without violating individual rights. The overarching goal of pharmacology should be to reduce the risks of those who use drugs without harming those who don't. Those who claim that this cannot be done, in advance of making a concerted effort to do it, are the ones who are truly anti-scientific. Perhaps the most common response to the call for elimination of animals in toxicity testing is the benefits argument. 1. Human beings and animals have benefited from toxicity tests on animals. 2. Therefore, these tests are justified. Like all arguments with missing premises, everything turns on what that premise is. If it read, "These tests do not violate the rights of animals," then we would be on our way to receiving an interesting defense of toxicity testing. Unfortunately for those who countenance these tests, however, and even more unfortunately for the animals used in them, that premise is not true. These tests do violate the rights of the test animals for the reasons given. The benefits these tests have for others are irrelevant, according to the rights view, since the tests violate the rights of the individual animals. As in the case of humans, so also in the case of animals. Overriding their rights cannot be defended by appealing to the general welfare. Put alternatively, the benefits others receive count morally only if no individual's rights have been violated. Since toxicity tests of new drugs violate the rights of laboratory animals, it is morally irrelevant to appeal to how much others have benefited. Footnote. The benefit argument sometimes is advanced, especially by veterinarians, in defense of testing for the toxicity of drugs on some animals in the hope that other animals might benefit. It is true that some animals have benefited because these tests have been done on others, but this does not provide a moral justification of these tests. Just as animals used in the laboratory are not resources to be used in the name of obtaining human benefits, so are they not to be viewed as a resource to be used in pursuit of benefits for other animals. End footnote. A further objection is conceptual in nature. Animals cannot volunteer or refuse to volunteer to take part in toxicity tests, it may be claimed, and so cannot be forced or coerced to take part in them either. Thus, the rights view's opposition to using them is fatuous. Now, it is true that, unlike some humans, animals cannot give or withhold their informed consent relative to participation in a toxicity test. But this is because they cannot be informed in the relevant way. It is no good trying to inform them about pH factors and carcinogens. They will not understand because they cannot understand. But it does not follow from this that animals cannot be forced or coerced to do something they do not want to do. Because these animals are intelligibly viewed as having preference autonomy, we are able intelligibly to say and confirm statements made about what they want, desire, prefer, aim at, intend, and so forth. We can, therefore, give a perfectly clear sense to saying that they are being forced or coerced to do something they do not want to do. Beyond any doubt, those animals used in the LD50 test, for example, are not doing what they want to do, and those who use them in these tests do so by means of force or coercion. To establish the scientific validity of non-animal toxicity tests is a difficult challenge, certainly, one that can only be met by scientists. No moral philosophy can do this. What a moral philosophy can do is articulate and defend the morally permissible means of conducting science. If the rights view has the best reasons on its side, this is the view we ought to use to assess what is and what is not permissible in the case of toxicity testing. And the implications of this view are clear. Toxicity tests of new products and drugs involving animals are not morally justified. These tests violate the rights of these animals. They are not morally tolerable. All ought to cease. Scientific research. One can imagine someone accepting the arguments advanced against toxicity tests on animals, but putting his foot down when it comes to scientific research. To deny science use of animals in research is, it might be said, to bring scientific and allied medical progress to a halt, and that is reason enough to oppose it. The claim that progress would be brought to a halt is an exaggeration, certainly. It is not an exaggeration to claim that, given its present dominant tendency, the rights view requires massive redirection of scientific research. The dominant tendency involves routinely harming animals. It should come as no surprise that the rights view has principled objections to its continuation. A recent statement of the case for unrestricted use of animals in neurobiological research contrasts sharply with the rights view and will serve as an introduction to the critical assessment of using animals in basic research. The situation, as characterized by C.R. Gallistel, a psychologist at the University of Pennsylvania, is as follows. Behavioral neurobiology tries to establish the manner in which the nervous system mediates behavioral phenomena. It does so by studying the behavioral consequences of one or more of the following procedures. A. Destruction of a part of the nervous system. B. Stimulation of a part. C. Administration of drugs that alter neural functioning. These three techniques are as old as the discipline. A recent addition is D. The recording of electrical activity. All four cause the animal at least temporary distress. In the past, they have frequently caused intense pain, and they occasionally do so now. Also, they often impair an animal's proper functioning, sometimes transiently, sometimes permanently. The animals subjected to these procedures are, in a word, harmed. When it comes to advancing our knowledge in neurobiology, however, there is no way to establish the relation between the nervous system and behavior without some experimental surgery. Whereby experimental surgery, Gallistel evidently means to include the four procedures just outlined. The issue, then, in Gallistel's mind, is not whether to allow such surgery or not, it is whether any restrictions should be placed on the use made of animals. Gallistel thinks not. In defense of unrestricted use of animals in research, Gallistel claims that most experiments conducted by neurobiologists, like scientific experiments generally, may be seen in retrospect to have been a waste of time, in the sense that they did not prove or yield any new insight. But, claims Gallistel, there is no way of discriminating in advance the waste of time experiments from the illuminating ones with anything approaching certainty. The logical upshot, so Gallistel believes, is that restricting research on living animals is certain to restrict the progress in our understanding of the nervous system and behavior. Therefore, he concludes, One should advocate such restrictions only if one believes that the moral value of this scientific knowledge and of the many human and humane benefits that flow from it cannot outweigh the suffering of a rat, something that, writing autobiographically, Gallistel finds an affront to my ethical sensibility. Even those unpersuaded by the rights view ought to challenge Gallistel's argument at every point. Is it true, as he claims, that there is no way to establish the relation between the nervous system and behavior without some experimental surgery? Can we learn nothing whatever about this connection from, say, clinical observation of those who have been injured? Again, is it true that we can never say in advance that a given proposal has been drawn up by an incompetent researcher who doesn't know what he is looking for and wouldn't recognize it if he found it? What could be the grounds for peer review of research proposals if Gallistel's views were accepted? Why not draw straws instead? Those stirrings in the scientific community, away from unrestricted use of animals toward the refinement of one's protocol, thereby eliminating so-called unnecessary experiments, and reduction in the number of animals used, will find no support from the no-holds-barred approach Gallistel advocates. Since there is, in his view, no way to separate the scientific wheat from the chaff in advance of experimenting, why worry about refinement? Why worry about reduction? These matters aside, the rights view rejects Gallistel's approach at a more fundamental level. On the rights view, we cannot justify harming a single rat merely by aggregating the many human and humane benefits that flow from doing it, since, as stated, this is to assume that the rat has value only as a receptacle, which on the rights view is not true. Moreover, the benefits argument that Gallistel deploys is deficient. Not even a single rat is to be treated as if that animal's value were reducible to his possible utility relative to the interests of others, which is what we would be doing if we intentionally harmed the rat on the grounds that this just might prove something, just might yield a new insight, just might produce benefits for others. It bears emphasizing that the rights view's critique of the use of animals in research is unlike some that find favor in the literature on this matter. Some object on methodological grounds, arguing that the results of such research offer very little hope of benefits for humanity because of the by now well-established difficulty of extrapolating results from animal tests to the species Homo sapiens. Others challenge the necessity of a variety of experiments, cases where animals have been cut, blinded, deformed, mutilated, shocked into learned helplessness, and so on, all in the name of research. Neither of these critical approaches, though each has clear validity as far as it goes, gets to the moral heart of the matter. It is not that the methodology is suspect, though it is, nor that a great deal of research is, Gallistel's opinion to the contrary notwithstanding, known to be a waste of time before it is undertaken. The point to note is that both these challenges invite the continuation of research on animals, the latter because it would rule out only that research known to be a waste of time before it is conducted, and the former because it gives researchers a blank check to continue animal experiments in the hope of overcoming the deficiencies in the present methodology. If we are seriously to challenge the use of animals in research, we must challenge the practice itself, not only individual instances of it or merely the liabilities in its present methodology. The rights view issues such a challenge. Routine use of animals in research assumes that their value is reducible to their possible utility relative to the interests of others. The rights view rejects this view of animals and their value, as it rejects the justice of institutions that treat them as renewable resources. They, like us, have a value of their own, logically independently of their utility for others and of their being the object of anyone else's interests. To treat them in ways that respect their value, therefore, requires that we not sanction practices that institutionalize treating them as if their value was reducible to their possible utility relative to our interests. Scientific research, when it involves routinely harming animals in the name of possible human and humane benefits, violates this requirement of respectful treatment. Animals are not to be treated as mere receptacles or as renewable resources. Thus does the practice of scientific research on animals violate their rights. Thus ought it to cease, according to the rights view. It is not enough first conscientiously to look for non-animal alternatives, and then, having failed to find any, to resort to using animals. Though that approach is laudable as far as it goes, and though taking it would mark significant progress, it does not go far enough. It assumes that it is all right to allow practices that use animals as if their value were reducible to their possible utility relative to the interests of others, provided that we have done our best not to do so. The rights view's position would have us go further in terms of doing our best. The best we can do in terms of not using animals is not to use them. Their inherent value does not disappear just because we have failed to find a way to avoid harming them in pursuit of our chosen goals. Their value is independent of these goals and their possible utility in achieving them. A variant of the lifeboat case discussed earlier is likely to surface at this point, if not before. Let us suppose that the lifeboat contains 4 normal adults and a dog. Provisions are plentiful this time, and there is more than enough room. Only now suppose the humans have a degenerative brain disease, while the dog is healthy. Also on board, so it happens, is a new medicine that just might be the long-awaited cure of the disease the humans have. The medicine has not been tested. However, it is known to contain some potentially fatal compounds. The means exist to give the degenerative disease to the dog. In these dire circumstances, would it be all right to do this and then to administer the medicine to the animal to assess its curative properties? Quite possibly, most people would give an affirmative reply, at least initially, but not those who subscribe to the rights view. Animals are not to be treated as if their value were reducible merely to their possible utility relative to human interests, which is what the survivors would be doing if they made the healthy animal, who after all stands to gain nothing and lose everything, run their risks in their stead. Some might seize upon this verdict of the rights view as a basis for urging what they regard as a fatal objection. Since most people think it would be all right to give the medicine to the dog, since the rights view allows appeals to what most people think as a basis for testing alternative moral principles and theories, and since what most people think in this case conflicts with the verdict of the rights view, it follows, some may think, that the practice of using animals in harmful research is justifiable. 3 replies must suffice. First, just because most people think the dog should be treated as described, assuming that most do so, it does not follow that most people think well in this case. Our pre-reflective intuitions, as was explained in an earlier chapter, must be tested reflectively to determine how well they stand up under the conscientious attempt to reach an ideal moral judgment. Without making this attempt, those who are content to appeal to what most people think have no rational basis to assume that what most people think in any given case is not based on their shared ignorance, their shared prejudices, or their shared irrationality. Merely to appeal to what most people think, in other words, is not decisive in this or in any other moral context. Second, even in those cases where a given belief continues to be held by most people after they have made a conscientious effort to remove the insidious effects of ignorance, prejudice, and the like, the possibility still remains that the belief in question stands in need of revision or abandonment. For if a given belief cannot be squared with moral principles that themselves pass the relevant tests for assessing their validity, namely scope, precision, consistency, and conformity with a host of other intuitions that stand up on reflection, one must come to doubt the rational grounds of that belief and others like it in the relevant respects. Again, then, merely to announce that after having given the matter one's conscientious attention, one still thinks that the dog should be treated as described in the lifeboat case is not to mount a serious challenge to the rights view or its verdict in this case. A serious challenge can be raised only if, in addition to citing one's belief in this case, one also adduces the general principles that would support it and shows that these principles are equal or superior to the rights view when these principles are themselves subjected to the tests of scope, precision, and the like. But third, and here we echo earlier observations, the justice of policies or practices are not guaranteed by generalizing on one's judgment in exceptional cases, and lifeboat cases, as was mentioned earlier, are exceptional cases. To make the danger of generalizing on such cases clearer, imagine that the lifeboat contains 4 exceptional and 1 average human. Suppose the 4 are preeminent scientists, each on the verge of making discoveries that portend enormous health benefits for humanity. The 5th man delivers Twinkies to retail stores in Brooklyn. The 4 scientists have the degenerative brain disease. The Twinkies delivery man does not. Would it be permissible to give the disease to him and then test for the drug's efficacy by administering it to him first? No doubt many people would be inclined to reply affirmatively, though not, again, those who subscribe to the rights view. Even among those who think the delivery man should serve as the proverbial guinea pig in these exceptional circumstances, however, none with the slightest egalitarian tendencies would be willing to generalize on the basis of this unusual case and favor a policy or practice of doing research on average humans, so that humans who are very bright or who make large social contributions might benefit. Such a practice leaves the bad taste of perfectionism in our mouths. The rights view categorically rejects perfectionism as a basis for assessing the justice of practices involving humans, whether in science or elsewhere, and so should we all. But just as perfectionism is not an equitable basis for assessing the justice of practices involving humans, so it is an unacceptable basis for assessing the justice of practices involving animals. And it is implicit allegiance to perfectionism that would tempt one to sanction the harmful use of animals in research, their lesser value being sacrificed for the greater value of humanity. Grounded in the recognition of the equal inherent value of all those who have inherent value, the rights view denies that a distinction between lesser and greater should be made where the perfectionist defense of the use of animals in research requires it. Thus does it deplore the continuation of this practice. The rights view does not oppose using what is learned from conscientious efforts to treat a sick animal, or human, to facilitate and improve the treatment tendered other animals or humans. In this respect, the rights view raises no objection to the many human and humane benefits that flow from medical science and the research with which it is allied. What the rights view opposes are practices that cause intentional harm to laboratory animals, for example, by means of burns, shock, amputation, poisoning, surgery, starvation, and sensory deprivation, preparatory to looking for something that just might yield some human or humane benefit. Whatever benefits happen to accrue from such a practice are irrelevant to assessing its tragic injustice. Lab animals are not our tasters. We are not their kings. The tired charge of being anti-scientific is likely to fill the air once more. It is a moral smokescreen. The rights view is not against research on animals if this research does not harm these animals or put them at risk of harm. It is apt to remark, however, that this objective will not be accomplished merely by ensuring that test animals are anesthetized, or given post-operative drugs to ease their suffering, or kept in clean cages with ample food and water, and so forth. For it is not only the pain and suffering that matters, though they certainly matter, but it is the harm done to the animals, including the diminished welfare opportunities they endure as a result of the deprivations caused by the surgery and their untimely death. It is unclear whether a benign use of animals in research is possible, or, if possible, whether scientists could be persuaded to practice it. That being so, and given the serious risks run by relying on a steady supply of human volunteers, research should take the direction away from the use of any moral agent or patient. If non-animal alternatives are available, they should be used. If they are not available, they should be sought. That is the moral challenge to research given the rights view, and it is those scientists who protest that this can't be done in advance of the scientific commitment to try, not those who call for the exploration, who exhibit a lack of commitment to and belief in the scientific enterprise, who are, that is, anti-scientific at the deepest level. Like Galileo's contemporaries who would not look through the telescope because they had already convinced themselves of what they would see and thus saw no need to look, those scientists who have convinced themselves that there can't be viable scientific alternatives to the use of whole animals in research, or toxicity tests, etc., are captives of mental habits that true science abhors. The rights view, then, is far from being anti-scientific. On the contrary, as is true in the case of toxicity tests, so also in the case of research. It calls upon scientists to do science as they redirect the traditional practice of their several disciplines away from the reliance on animal models toward the development and use of non-animal alternatives. All that the rights view prohibits is science that violates individual rights. If that means that there are some things we cannot learn, then so be it. There are also some things we cannot learn by using humans if we respect their rights. The rights view merely requires moral consistency in this regard. The rights view's position regarding the use of animals in research cannot fairly be criticized on the grounds that it is anti-humanity. The implications of this view in this regard are those that a rational human being should expect, especially when we recall that nature neither respects nor violates our rights. Only moral agents do, indeed, only moral agents can, and nature is not a moral agent. We have, then, no basic right against nature not to be harmed by those natural diseases we are heir to, and neither do we have any basic right against humanity in this regard. What we do have, at this point in time at least, is a right to fair treatment on the part of those who have voluntarily decided to offer treatment for these maladies, a right that will not tolerate the preferential treatment of some, for example, Caucasians, to the detriment of others, for example, Native Americans. The right to fair treatment of our naturally caused maladies, and the same applies to mental and physical illnesses brought on by human causes, for example, pollutants, is an acquired right we have against those moral agents who acquire the duty to offer fair treatment because they voluntarily assume a role within the medical profession. But those in this profession, as well as those who do research in the hope that they might improve healthcare, are not morally authorized to override the basic rights of others in the process. Rights others have, that is, independently of their place in any institutional arrangement and independently of any voluntary act on the part of anyone. And yet that is what is annually done to literally millions of animals, whose services, so to speak, are enlisted in the name of scientific research, including that research allied with medical science. For this research treats these animals as if their value is reducible to their possible utility relative to the interests of others. Thus does it routinely violate their basic right to respectful treatment. Though those of us who today are to be counted among the beneficiaries of the human benefits obtained from this research in the past might stand to lose some future benefits, at least in the short run if this research is stopped, the rights view will not be satisfied with anything less than its total abolition. Even granting that we face greater prima facie harm than laboratory animals presently endure if future harmful research on these animals is stopped, and even granting that the number of humans and other animals who stand to benefit from allowing this practice to continue exceeds the number of animals used in it, this practice remains wrong because unjust. A further objection has a distinctively contractarian flavor. As a society, it might be claimed, we have decided that the use of animals for scientific purposes, even their harmful use, is permissible. Anyone who becomes a scientist in a nation that supports science by the use of public funds acquires the duty to serve the public will, and the public has a right against scientists to do so. Since the harmful use of animals in pursuit of scientific purposes is necessary if science is to fulfill the terms of its contract with society, the existence of this contract is a special consideration that justifies the continued use of animals in science. The rights view is not unsympathetic to appeals to contracts and other voluntary arrangements as a basis for validating acquired duties and correlative rights. As was observed in an earlier discussion of these issues, however, the moral validity of a contract or other voluntary arrangement is not shown just by establishing that certain individuals voluntarily entered into a given agreement. Moral validity depends upon the respectful treatment of all those involved, not just those who enter into the agreement. A slave trader does not do what is right by supplying his client with a promised slave, and he has no valid moral duty to do so, despite his promising to do so. Since the institution of slavery treats slaves with a lack of respect, promises made in the name of the perpetuation of this institution are morally null and void. The same is true regarding society's contract with science and the supposed duty of scientists to carry out their end of the agreement by harming some animals so that others, both humans and animals, might benefit. This contract has no moral validity, according to the rights view, because it fails to treat lab animals with the respect they are due. That science that routinely harms animals in pursuit of its goals is morally corrupt because unjust at its core, something that no appeal to the contract between society and science can alter. What is required is a new contract, one that takes account of and respects those currently exploited by the existing one, a contract that, if it cannot be drawn up and enforced by education and opinion, will have to take the form of law. Only then will society's contract with science constitute a valid special consideration. Though the efforts of many are needed to forge the terms of this new contract, the efforts of veterinarians are especially important. Veterinarians are the closest thing society has to a potential role model for the morally enlightened care of animals. It is, therefore, an occasion for deep anguish to find members of this profession increasingly in the employ of or rendering their services to the very industries that routinely violate the rights of animals, the farm animal industry and the lab animal industry, for example. On the rights view, veterinarians are obliged to extricate themselves and their profession from the financial ties that bind them to these industries, and to dedicate their extensive medical knowledge and skills as healers, as doctors of medicine, to projects that are respectful of their patients' rights. The first signatures in the new contract involving justice in animals should be from those who belong to the profession of veterinary medicine. To fail to lead the way in this regard will bespeak a lack of moral vision or courage, or both, that will permanently tarnish the image of this venerable profession and those who practice it. A final objection urges that the rights view cannot have any principled objection to using mammalian animals for scientific purposes generally, or in research in particular, before these animals attain the degree of physical maturity that makes it reasonable to view them as subjects of a life, in the sense that is central to the rights view. For example, use of newly born mammalian animals must stand outside the scope of the prescriptions issued by the rights view. This objection is half right. If certain conditions are met, the rights view could sanction the scientific use of mammalian animals at certain stages of their physical development. As has been remarked on more than one occasion in the proceeding, however, where one draws the line, both as regards what species of animals contain members who are subjects of a life, and as regards when a given animal acquires the abilities necessary for being such a subject, is controversial. We simply do not know, with anything approaching certainty, exactly where to draw the line in either case. Precisely because we are so palpably ignorant about a matter so fraught with moral significance, we ought to err on the side of caution, not only in the case of humans, but also in the case of animals. Though during the earliest stages of development it is most implausible to regard a fetal mammalian animal as conscious, sentient, and so on, It becomes increasingly less implausible as the animal matures physically, acquiring the physical basis that underlies consciousness, perception, sentience, and the like. Although throughout the present work attention has been for the most part confined to normal mammalian animals, aged 1 or more, it does not follow that animals less than 1 year of age may be treated in just any way we please. Because we do not know exactly where to draw the line, it is better to give the benefit of the doubt to mammalian animals less than 1 year of age who have acquired the physical characteristics that underlie one's being the subject of a life. The rights view's position concerning those animals, then, is against their use for scientific purposes. There are Kantian-like grounds that strengthen the case against using newborn and soon-to-be-born mammalian animals in science. To allow the routine use of these animals for scientific purposes would most likely foster the attitude that animals are just models, just tools, just resources. Better to root out at the source than to allow to take root attitudes that are inimical to fostering respect for the rights of animals. Just as in the analogous areas of abortion and infanticide in the case of humans, therefore, the rights view favors policies that foster respect for the rights of the individual animal, even if the creation of these attitudes requires that we treat some animals who may not have rights as if they have them. Finally, even in the case of mammalian animals in the earliest stages of fetal development, the rights view does not issue a blank check for their use in science. For though, on the rights view, we do not owe a duty of justice to these fetuses, we do owe justice to those animals who would be enlisted to produce them in the number researchers are likely to desire. Were mature animals used as fetal machines, and as a result, were they housed in circumstances conducive to their reproducing at the desired rate, it is most unlikely that the rights of these mature animals would be respected. For example, it is very unlikely that these animals would be provided with a physical environment conducive to the exercise of their preference autonomy, or one that was hospitable to their social needs, and it is equally unlikely that they would avoid having their life brought to an untimely end well in advance of their having reached a condition where killing them could be defended on grounds of preference respecting or paternalistic euthanasia. Once they had stopped reproducing, they would likely be killed, to the extent that we have reason to believe that these mature animals would be treated as if they had value only relative to human purposes. To that extent, the rights view would oppose the scientific use of fetal mammalian animals, not because these latter have rights that would be violated, but because this would be true in the case of the mature animals used as breeders. Those who would use mammalian animals in the earliest stages of their fetal development, then, may do so, according to the rights view, but only if they ensure both that 1. The lab animals used to produce the fetuses are treated with the respect they are due, and that 2. Reliance on mammalian fetuses does not foster beliefs and attitudes that encourage scientists to use mature mammalian animals for scientific purposes, including research. It is unclear that science could institute policies that satisfied the first condition. It is clear that a policy could be introduced that satisfied the second. This would be for science to cease using mammalian animals who are subjects of a life in ways that harm them directly, or that put them at risk of harm, or that foster an environment in which their harm is allowed. That is a policy the rights view could allow, but one science has yet to adopt. Footnote. Note that replies analogous to those given in the last 3 paragraphs could be given in response to the view that it is all right to eat farm animals or to hunt or trap wild animals less than 1 year old, including those who are newly born and soon to be born. Concerning farm animals first, since 1. We do not know with anything approaching certainty that these young animals are not subjects of a life, since 2. Whether they are or not, we want to encourage the development of beliefs and attitudes that lead to the respectful treatment of those animals who are subjects of a life, and 3. Since the adult animals who would be used as fetal machines in agriculture would in all likelihood not be treated with the respect they are due, the rights view opposes this defense of meat eating. Points 1 and 2 apply to hunting and trapping newly born wild animals, and are the principal but not the only sorts of reasons the rights view gives against the slaughter of newly born seals, for example. The rights view offers reasons of the same kind in support of its condemnation of killing non-mammalian animals, for example, birds and fish of all kinds, in the name of sport or in pursuit of a profit. Even assuming birds and fish are not subjects of a life, to allow their recreational or economic exploitation is to encourage the formation of habits and practices that lead to the violation of the rights of animals who are subjects of a life. End footnote. Animals in Science, Utilitarianism, and Animal Rights. The fundamental differences between utilitarianism and the rights view are never more apparent than in the case of the use of animals in science. For the utilitarian, whether the harm done to animals in pursuit of scientific ends is justified depends on the balance of the aggregated consequences for all those affected by the outcome. If the consequences that result from harming animals would produce the best aggregate balance of good over evil, then harmful experimentation is obligatory. If the resulting consequences would be at least as good as what are otherwise obtainable, then harmful experimentation is permissible. Only if harmful experimentation would produce less than the best consequences would it be wrong. For a utilitarian to oppose or support harmful experimentation on animals, therefore, requires that he have the relevant facts: who will be benefited or harmed, how much, and so on. Everyone's interests, including the interests of those who do the tests or conduct the research, their employers, the dependents of these persons, the retailers and wholesalers of cages, animal breeders, and others, must be taken into account and counted equitably. For utilitarians, such side effects count. The animals used in the test have no privileged moral status. Their interests must be taken into account, to be sure, but not any more than anybody else's interests. As is almost always the case, utilitarians simply fail to give us what is needed, the relevant facts that we must have, given their theory, to determine whether use of animals in science is or is not justified. Moreover, for a utilitarian to claim or imply that there must be something wrong with a given experiment, if the experiment would not be willing to use a less intelligent, less aware human being, but would be willing to use a more intelligent, more aware animal, simply lacks a utilitarian basis. For all we know, and for all the utilitarian has thus far told us, the consequences of using such an animal, all considered, might be better than those that would result from using the human being. It is not who is used, given utilitarian theory, that matters. It is the consequences that do. The rights view takes a very different stand. No one, whether human or animal, is ever to be treated as if she were a mere receptacle, or as if her value were reducible to her possible utility for others. We are, that is, never to harm the individual merely on the grounds that this will or just might produce the best aggregate consequences. To do so is to violate the rights of the individual. That is why the harm done to animals in pursuit of scientific purposes is wrong. The benefits derived are real enough, but some gains are ill-gotten, and all gains are ill-gotten when secured unjustly. So it is that the rights view issues its challenge to those who do science. Advance knowledge, work for the general welfare, but not by allowing practices that violate the rights of the individual. These are, one might say, the terms of the new contract between science and society, a contract that, however belatedly, now contains the signature of those who speak for the rights of animals. Those who accept the rights view and who sign for animals will not be satisfied with anything less than the total abolition of the harmful use of animals in science, in education, in toxicity testing, in basic research. But the rights view plays no favorites. No scientific practice that violates human rights, whether the humans be moral agents or moral patients, is acceptable. And the same applies to those humans who, for reasons analogous to those advanced in the present chapter in regard to non-humans, should be given the benefit of the doubt about having rights because of the weight of our ignorance, the newly born and the soon-to-be-born. Those who accept the rights view are committed to denying any and all access to these resources on the part of those who do science. And we do this not because we oppose cruelty, though we do, nor because we favor kindness, though we do, but because justice requires nothing less. 9.5. Summary and Conclusion. This chapter traced some of the implications of the rights view. On this view, animal agriculture as we know it is unjust, and it is unjust because it fails to treat farm animals with the respect they are due, treating them instead as renewable resources having value only relative to human interests. Animal agriculture as we know it is wrong, not only when farm animals are raised in close confinement in factory farms, but also when they are raised humanely, since even in this case their lives are routinely brought to an untimely end because of human interests rather than on grounds of preference-respecting or paternalistic euthanasia. Those who support current animal agriculture by purchasing meat have a moral obligation to stop doing so. There is no credible basis for claiming that consumers would be made worse off than the animals involved if consumers became vegetarians. And though those whose quality of life currently is tied to the vitality of the animal industry might be made worse off if that industry fails, their voluntary participation in that business signals that they waive the right not to be made worse off if the business fails. We do not owe it to any farmer, meat packer, or wholesaler to buy their products, and neither do we owe this to their dependents. It is no criticism of the rights view, moreover, to note that once deprived of a suitable economic incentive to raise farm animals, farmers will raise few, if any, animals for commercial gain, since it is the justice of how individual animals are treated, not the number of domesticated animals there are, that is morally central. To protest that farm animals, as legal property, may be treated in whatever way their legal owners see fit is lame, first, because what is legal is not necessarily moral, and second, because the rights view challenges the very conception of animals as legal property. In sharp contrast to the utilitarian basis of the obligation to be vegetarian, the rights view holds that the individual has a duty to lead a vegetarian way of life independently of knowing how many others are doing so, and independently of knowing how large or small is the vegetarian impact on the market in meat. The individual is right to withhold support from institutions that violate the rights of others, even if the individual is the only one to do so. Like utilitarian advocates of vegetarianism, however, those who subscribe to the rights view call upon individual vegetarians to do more than simply abstain. The rights view will not be satisfied with anything less than the total dissolution of the animal industry as we know it. Hunting and trapping, whether for sport or commerce, were assessed from the perspective of the rights view. Both were roundly condemned. The pleasures derived from these sports, for example, communion with nature, can be secured without killing animals, and the commercial exploitation of wildlife erroneously assumes that the value of wild animals is reducible to their utility relative to human interests, especially economic interests. To attempt to avoid these criticisms by taking refuge in the philosophy of maximum sustainable yield is unsuccessful. That philosophy perpetuates the view that wild animals are a renewable resource, having value only relative to human interests. Thus does it perpetuate, rather than correct, an impoverished view of the value of these animals. Moreover, the successful implementation of the philosophy of maximum sustainable yield would actually maximize rather than reduce the total number of animals that would be killed, and the total number that would endure a bad death as a result of starvation, a hunter's poor shot, and so on. Sport and commercial hunters and trappers do not do wildlife any favor, are not friends of wildlife by practicing the philosophy of maximum sustainable yield. Wildlife managers who subscribe to this philosophy are part of the problem, not part of the solution. In general, the rights view's position is to let wildlife be. Wildlife management ought to be designed to protect wild animals against hunters, trappers, and other moral agents. This will require the abolition of the traditions of legalized hunting and trapping, as well as the dismantling of all commerce in wild animals, for example, the fur industry and whaling. Because paradigmatic right holders are individuals, and because individuals do not acquire any further rights if they belong to rare or endangered species, the rights view does not acknowledge any privileged moral status on the part of members of rare or endangered species of animals. However, the rights view is not opposed to efforts to save rare or endangered animals. It only insists that these animals be protected because they are animals, not because they are rare or endangered. Moreover, to the extent that efforts to protect rare and endangered species foster beliefs and attitudes that place less importance on the value of plentiful animals, to that extent the rights view must lodge its strong moral dissent. All animals are equal, both the plentiful and the rare. The central importance of the individual, given the rights view, poses unresolved questions about the ability of those who subscribe to it to develop an environmental ethic. At least at the level of theory, the rights view is at odds with the holistic or systems approach that characterizes much of contemporary thought about the environment, environmental fascism, so-called. In particular, the rights view rejects the aggregative implications of a theory like Leopold's, an approach that would have us assess the morality of what we do by summing the consequences for members of the biotic community, approving of what brings about the best consequences for the community, disapproving of what brings about less than the best. The rights view rejects this approach to moral decision-making and the theory of the value of the individual on which it rests. At the level of practice, however, the implications of the rights view, especially regarding wilderness preservation, could well be in harmony with the causes championed by environmentalists. Though a rights-based environmental ethic has yet to be formulated, let alone adequately assessed, such an ethic remains a live theoretical option. It should not be dismissed out of hand. The use of animals in science was the final area for which the major implications of the rights view were set forth. For a variety of reasons, the rights view takes a principled stand against the use of animals in educational contexts, in toxicity testing of new products and drugs, and in research. Dissection of living mammalian animals in high school and university lab sections is to be condemned, all the more so since the relevant knowledge obtained by this practice can be secured without engaging in it. To anesthetize these animals will not avoid the rights view's condemnation, since it is the animal's untimely death, not merely their pain or suffering, that is morally relevant. To the objection that most animals used in high school and university labs are not mammals, and so do not fall within the scope of the principles advocated by the rights view, it was noted that, 1, where we draw the line between those animals that are and those animals that are not subjects of a life is far from certain, so that we ought to err on the side of caution, giving animals the benefit of the doubt in many cases, including the present one, and that, 2, routine use of even non-mammalian animals fosters beliefs and attitudes that contribute to acceptance of acts and institutions that fail to show respect for, and thus violate the rights of, mammalian animals. Both reasons provide compelling grounds for discontinuing standard lab sections in high school and university courses in the life sciences. Among the reasons offered against using animals in toxicity tests, the principal one is that risks are not transferable in the way reliance on this use of animals assumes. Whether in the case of new products or new drugs, individuals do not have a right to have the risks they can voluntarily choose to run or not run established or minimized by forcing others to find out what risks there are. The good consequences for others that do or might result are not relevant to the moral justification of toxicity tests any more than they are relevant in other cases where laudable ends are secured by reprehensible means. We are not to do injustice that good may come, not coercively to put others at risk of harm or harm them so that others might establish or minimize their risks. To approve toxicity tests on laboratory animals is to sanction the routine violation of their rights. On the rights view, all such tests must be stopped. This is not to say that toxicity tests should come to an end. On the contrary, inasmuch as it is desirable to minimize the risks we run if we choose to use a new product or new drug, the rights view applauds the development of valid scientific procedures that protect our interests in this regard, calling upon the involved commercial interests and the affected government regulatory agencies to make a conscientious commitment to protect humans in the home and workplace. All that the rights view prohibits are procedures that violate the rights of individuals. It is not reduction of the number of animals that is required, nor refinement of one's protocol. The rights view calls for the total elimination of the use of animals in toxicity tests. The same call is made by the rights view when it comes to the use of animals in research. To harm animals on the chance that something beneficial for others might be discovered is to treat these animals as if their value were reducible to their possible utility relative to the interests of others. And to do this, not to a few, but to millions of animals, is to treat the affected animals as if they were a renewable resource. Renewable because replaceable without any wrong having been done, and a resource because their value is assumed to be a function of their possible utility relative to the interests of others. The rights view abhors the harmful use of animals in research and calls for its total elimination. Because animals have a kind of value that is not the same as, is not reducible to, and is incommensurate with their having utility relative to the interests of others, because they are owed treatment respectful of their value as a matter of strict justice, and because the routine use of laboratory animals in research fails to treat these animals with the respect they are due, their use in research is wrong because unjust. The laudatory achievements of science, including the many genuine benefits obtained for both humans and animals, do not justify the unjust means used to secure them. As in other cases, so in the present one, the rights view does not call for the cessation of scientific research. Such research should go on, but not at the expense of laboratory animals. The overarching challenge of scientific research is the same as the similar challenge for toxicology and all other facets of the scientific enterprise: to do science without violating anyone's rights, be they human or animal. The rights view does not deny in principle that use of mammalian embryos in science, including research, might be justified. Fetuses in the early stages of their development can be used, according to the rights view, if we have good reason to believe that allowing their use will not foster beliefs and attitudes that sanction treatment violative of the rights of those animals who have rights, in particular, the rights of those animals used as breeders. Though it is not clear that this challenge can be met, it is clear that it cannot be met if scientists themselves continue to use both mammalian embryos and mature animals. An essential part of the evidence necessary to justify use of mammalian embryos, therefore, consists in scientists not using mature mammalian animals, or other mammalian animals who, though less than 1 year old, ought to be given the benefit of the doubt. As such, the rights view will take seriously a defense of the use of mammalian embryos only when scientists themselves cease using mammals at later stages of their life, but not until then. The onus of proof is where it belongs.